Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
We will bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict's live stream in their court.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican po rin, pero that's
literally not true.
I didn't ask you to interrupt me.
Is that correct?
Oh, for Trump's sake.
Good morning, good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. Happy Taco Tuesday to you. I'm running solo today. Mrs. R.A. took the younger kids to the aquarium and to go pick up our. Remember when our door got shut out? To pick up our door that's been finally repaired, and a couple windows that need to be repaired as well. So she's off doing the hard work, and I'm here with you all. Good morning, good morning. Hope you had a good evening. Welcome. Come on and take a seat. It's great to be with y'all. How's everybody doing? Well, I've got some of my older kids here, but I'm sort of supervised, for sure. Let's see. Kimmy Sue, thank you for responding to my Carmelo Anthony case. No problem, Kimmy Sue. I'm sorry it was a month late. I'm sorry that it took me a month to respond. I do try to read all my messages. That one snuck in on a side of the messenger that I rarely get contacted on. And through Facebook, like a direct message that I just didn't see in the queue. Unfortunately, the judge in the Carmelo Anthony case has locked that thing tighter than Fort Knox. There will be no recording. There will be no video. There will be no live tweeting from the courtroom. You are allowed to bring your own, printing press into the courtroom where you can set your own type manually, and then print a page if you like. It's way back in the olden days. I mean he's literally shut that thing down, and he has some valid concerns because there is a huge racial tension involved in that case. And my studio changed. What changed? I just bumped my camera. Bring it down a little bit. My studio's completely different. What's up? I just took my audio box. See this box right here? I have another one that's exactly the same size that was on top of it, but it blocked the TV, so I couldn't see it. I just took that down. I'm trying to find a better way so that I can get rid of something you can't see, which is a painter's ladder, one of those platform ladders over there. I need to get that out of here. Anyway, so the Carmelo Anthony case is a no-go for coverage. I mean, there will be like a handful of media people allowed to be there with, I think they have to bring like a quill and their own ink, and they can scratch out any notes they want during the trial. But that's about it. And he's banned like interviews. He's got a gag order in place for everybody until after the trial's over. So basically, no one's going to know what happens until after the verdict's read. All right, can we lower the lights and put chat on screen? I can do one of the two, a little bit. I can tip it down a little bit. All right, let's see. We have some stuff to do today. What's happening there? Oh, that's a pool feed. Never mind. Good morning. The blinds are open. No, but I will say this. Amanda H, 1, 2, 3, 4. Thank you very much for the corgi. I appreciate that. Let me tell you, I got an email today from YouTube, so maybe you did it as well. I'm not sure. It might have gone to your spam. But remember when they gave us jewels, like the little jewels to give away? They expire June 10th. If you haven't spent them, they're gone. I'm not saying you have to spend them on me. But if you have no one else to spend them on, I'd be happy to take them off your hands. So if you have some jewels, thank you. Amanda H just used all 1,000 of hers for the corgi. Thank you, Amanda. That's wonderful. All right, we have some babies to celebrate today. Twin grandbabies. That's awesome. Let's see. Oh man, they're Anna's YouTube account just gifted and Greeners and Scotch Mom. Oh, it's flooding in, guys. We need to do birthdays first. Let's do birthdays really quickly. We've got Eric, who's Caffeine Queen's son, Linda, and then Ruth Ann's twin grandbabies. That's how we're going to sing it in the song. We're going to go back and see McNally's. I can't click on all these. They're going too fast. We have to, birthdays first, guys. Birthdays first. Focus. Be with me. Wherever you are. Wherever you are. If it's legal and you're able, stand up, take a deep breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbor, and warm up with me if you will. La 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 la. Oh, it's going to be good today, I can tell. Although I don't have any water. Okay, it's a good thing it's not Wednesday. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, dear Eric, Linda, and Ruth Ann's twin grandbabies. Happy birthday to you. Thank you very much. Oh my goodness. To everyone who celebrated their birthday today, happy birthday. I realize there are a million places you could be and a million people you could have celebrated with, but you chose to be here with us. The privilege, pleasure, the honor, the joy is ours. Hopefully we can turn that joy back to you. Make your day just a little bit more special. Begin by helping yourself to free pancakes at Denny's, IHOP Village Inn, Waffle House, McDonald's, Tammy Dunlop's House, Sandy's Grill, Bob Evans, and Cracker Barrel. Woo! I'm trying to keep up with all these stickers, all these little actions. The hydrate turtle. Yes, I need to hydrate. Music is loud today. That's my fault. Dancers are doing great. Floor's lava dancers. Ooh. Thanks for the sunshine as well. Y'all are amazing. Sun balloon. All right, let's see. We've got a little more dancing and pancakes to go on. The dancers have been practicing. Oh, Lee and Paula Mac's anniversary today. Happy anniversary. That's awesome. This is like, you guys are both still 24, right? I'm pretty sure. So this will be like a third anniversary for you. I don't know. Happy anniversary. I'm never good at guessing ages. You look young. Cass, thanks for the sunshine as well. We've got tulips coming in from Fairby Mids. Another goat trophy. This one from Ruth Ann. Thank you so much. Anniversary week too, yes. Drum solo. Let's do this part. This is my only exercise today. Beautiful. Thank you very much for all those, the sunshine and the goats and the huskies and the laughing disco balls. They're just flooding in. You guys are way too kind. That is awesome. Let's see if we have any, let's see, we've got, that one's over there, and it's off. This one's over there, and it's off. Okay, we're good, I think we have everything set up that we need. Tomorrow is a big day because not only do we have trial with Judge Boyd, which is starting today, opening statements this afternoon in just a couple hours. We also have Corey Richards sentencing tomorrow, and it's my anniversary. So if you have ideas for what I need to do for anniversary, send them now because I need some help. Who owns the internet, I wonder? Well, Fran Fitzgerald, that would be you. Congratulations. You were first in chat. You said hi right here. So I had it saved. Everything IP related worldwide is your responsibility, Fran. Your promptness and punctuality has got you yet again another punishment. This makes you a repeat offender. Yay, even a habitual offender. Recidivism, not a problem for you. You've got it nailed. So congratulations and good riddance a little bit. These super stickers are going nuts. Let's see. We've got cheers. Thanks for the cheers, Troy. Appreciate that. Anna sent another one here. We've got a high five from Red Pen. Thank you. Amanda Brown. They're not all appearing when I click. Why not? Amanda Brown, thank you very much. Also, Red Pen sent some sunshine. Red, thanks very much. Sunshine back to you, Red Pen. Hope your day is good. Thanks for being here. And we're thinking of you today, especially. Okay. Tomorrow is Hump Day as well. Hump Day on the anniversary. Go figure. All right.
Shame on you, sir.
Yes. Isn't today Paul Canero sentencing? It may be. Might have to take a peek at that. We were going to... I meant Karen Reed, but I said the right one, Corey Richens. Let's see. Anna's like, finally got rid of those jewels. Good job. Good job, Anna. They're not going to be pesky, hanging around. And they won't go to waste either. So I promise I'll put them to good use. Let's do a little check on the Paul Canero side and see what that is. Didn't it get pushed out a little bit? It's thinking about it. It was originally set for today. It was rescheduled after he lost his bid for a new trial, so it's now... Let's see, May 19th. Okay, so we've got another week out. How do you find Jules? I think it's down next to, it's at the bottom of the chat window on your screen. I think it's where the... I think it's where the little dollar sign is. I think. I'm not sure. Daily Free Nomad. Does anyone know who will be covering the Larry Millett trial? Showing live updates as no cameras are allowed in court. Larry Millett. The name's really familiar. That one is San Diego, California. Jury selections going on. The trial lasts 3 months. No cameras are live streaming in the courtroom to project the jury, as if the cameras can't avoid the jury. Your best bet is going to be your big news stations in that area. So you're going to have Fox 5, NBC 7, and 10 News. Basically the same people who bring us most of the California police chases. They're going to probably be the ones to follow it because they'll need somebody in the courtroom and in person without... Yeah, that's about all you can do. Y'all, thank you for all the jewels. That is so cool. I appreciate that. Britta Aller has a milestone. Let me go back and check the milestones. I forgot to look at those this morning. And whoa, all the jewels things show up. This is awesome. Britta Aller, member for 36 months. OG says, finally in the Red Club. Thank you guys for your support. You guys are amazing. It's not the same without my dad here. Britta, I'm so sorry. It is not the same. It wouldn't be the same without you here either. You bring something important here to the channel. And thank you very much. OG, 36 months. Ruth Ann, member for 40 months. OG. Thank you, Ruth Ann. Judy Freese, welcome to the gallery. I think you're about an OG as well. And another OG, Mimi D, member for 36 months, also in red. Congratulations, OG. That's awesome. That is just awesome. All right, Shelly Small gifted 5 memberships. Thank you very much, Shelly. Now let's see if we can find this morning. There was something going on with Judge Dad. He's back on the bench live now, so he's still working. But there was something he was having some issues with this morning, and I'm trying to find where it was at. We might have to go back and... I thought it was about right here. A lot of people zooming in on this one today, which just presents problems for, a good judge like him, who's technology is not his strong suit. Josh Hutchins, welcome to Attorney OG. Josh, thank you very much. Fantastic supporter, amazing moderator, and helps the channel a zillion times over, all while catching personal best records nonstop from the dock. Impressive, Josh, to say the least. Sydney, enjoy the moment. Member for 10 months on the jury. Best channel ever. Y'all make me smile. Love and hugs to all. Thank you, Cindy. Thank you so much. I appreciate that. You make us smile as well. Shelly Small, I'm watching my great-grandson. Every time he hears your voice, he looks around the room. What's his name? We could play a little trick on him. How old is he before we start traumatizing the child? We can do that. Groovy Jill, thank you very much for the guitar. The Sun Balloon from Gray Lady. By the way, I think Gray Goose is going to stick for the name for my wife's car, which I also think it's her car because she chose it. JMR, also with the headphones, thank you very much. Appreciate that as well. What age is acceptable to traumatize? Yeah, that's basically what I'm asking. At what point would it not be like, shame on you, sir, and be like, haha, that was sort of funny, but the poor kid. We sort of want to ride that line gently. Sort of like the favorite uncle when he pulls a prank. That's sort of like the area we're going to. Grey Goose is a vodka. It is. We're not going to tell the police that the car's name is Grey Goose, but it is a dark gray. I mean, if you think of a swan, well, if you think of an ugly duckling, which honestly that name was also selected initially, and my wife vetoed. It's that color of feathers before the white feathers come in. It's an ugly duckling. It does have 3 dents. I pushed hard for Trident to be its name, which then we could also, possibly get a sponsorship from the gum company, but they did not respond, and my wife didn't either. So it's like a slate color. I like Trident. I thought it was perfect, but anyway, we'll see. I think it's still in the shop. It'll be ready this morning. It's getting an alignment and new tires. So. All right. Let me look at Mod Chat. I'm pretty sure I might have been told exactly where to go on this. Mods are very good at telling me where to go. In a good way, not like a bad way. We have a call. Hello? Hello? Call failed. Not sure why it failed. It's like it. I think I got 2 calls at once. All right. I like the story of the ugly duckling. Yeah, but in this case, we're never going to fix the car. We don't fix cars. Like, we don't, if they have a dent, we don't take it into the shop and have them buff it out and all that. It's just like that becomes part of the car now. So it's never going to become beautiful. It's just going to stay the ugly duckling forever. I'm trying to see where Judge Dad.
Call from Selena.
Hey, Selena, I thought it was you. How are you doing?
Selena. Doing good. How are you?
Fabulous. Are you ready?
I'm doing much better.
Are you ready to go up to Park City tomorrow?
I am, and I was just letting you know. I will be wearing a lavender shirt.
All right.
So,
are you going to try to get in your same spot? I guess
yes.
It alternates. I guess I'm not sure.
It alternates, but I'll be against the wall on the back.
Okay.
This time.
Okay, you might have to sit up tall so we can see you, because sometimes there are tall people in front of you.
Right. I'll sit up tall, last row, back by the wall. But yeah, I'll try to sit up tall, or I might move if I'm blocked. Yeah, I'm a little bit nervous, but it'll be good.
It'll be good.
I'm a little bit nervous because I think it's going to be very emotional, of course. So
it will, and I don't know if there are going to be children present or speaking. That will obviously have impact on what's allowed to be broadcast and televised and things like that. So we're going to play it by ear.
Right.
but you'll have a sort of a front row seat to all of that, regardless of how it goes down on the broadcast. So.
Right. So that'll be good. I will call in and when it's over. But yeah, I've heard through the grapevine, they were talking about this last time, that her children were going to possibly either write a letter or something. So
I've heard also that her children don't want to be there, but they did have something to say. So the letter is most likely how it will be presented. If that's the case, we'll get to hear a family representative read the letter, or a lawyer read the letter, and then we'll be able to see it all. But
when I was there last time, they were saying that maybe somebody from DCFS was going to read the letter. So
yeah, DCFS has been, or I'm not sure if it's DCFS or the
Victims Advocate or something.
Victims Advocate
yeah,
has been working with them. So we'll see how that goes. They might say, I want to talk. I want to face her, and that would be a brave decision for a young child, a very tough one.
Oh my goodness, for sure.
That's in their right as well. So.
Oh, for sure, and it has impacted them.
Yep.
Absolutely.
Speaking of impact, you had a very traumatic trip to Hawaii, and you elongated your stay just because you just had to get more surfing in, or web surfing at the hospital, as the case may be.
Right.
How's everybody doing? How's your hubby?
He's doing much better now. He is doing much better, but it was so scary. I was thinking I wasn't going to get him home alive, and it was that critical when he got into the ER. He had no air exchange in his lungs, and it was really, really scary. So we're glad we're home, and he's doing better, and yeah. I'm thankful to God that he saved him so that I could have him for a little bit longer. Yeah. So anyway, thank you all for your concern and prayers. And it was very scary. It's like I read the doctor's report yesterday for the first time from the ER, saying he was in severe respiratory distress. He had absolutely no oxygen coming into his lungs, only CO2, which is that was the problem. They were ready to put him on a ventilator. So yeah. Oh, this all happened within just a few minutes.
You were about to go to the airport. I mean, you were about to.
We were at the airport.
Fly home.
We were at the gate. We were in line to scan our tickets, and I was behind him, so I didn't see. But the lady checking us in said, "Sir, are you okay?" And so I looked around, and he was not able to breathe. Yeah. And so she said, "We need to call the medics." So they called the medics first at the airport, and then after that, they couldn't get any air movement, so they called the ambulance. And Tripler Medical Center was just about 5 minutes away for us
that's
from the airport. Yeah. So that's where they took him. So, and, it's just like all a blur kind of until I think back now. But, man, they were rushing around working on him. They're so heroes. Fast.
Those doctors and nurses, they do amazing work. Selena, let him know that we're pulling for him and for you, and excited you got to go to Hawaii, and sorry that it had that little asterisk on your trip, but I'm sure you guys had some wonderful memories there as well, because I've seen some pictures. We have
wonderful memories. What we try to do is put our first week and our second week and separate them. Mm-hmm. Yeah. Because the first week was absolutely unbelievably awesome, and then the second week is the second week. So anyway, thank you for everyone for your prayers and caring, and
thank you for keeping us
I'm going to go now.
All right. We'll see you tomorrow, literally.
Yep. See you tomorrow. I'll call in after. Okay. Bye.
Bye-bye. All right. Thank you for the update, Selena. We're gonna go to Judge Dad now, who's got had a little bit of his hands full this morning, and let's see, it's going to be on camera 7. So give us a second here.
Which are in custody for 60 days. Yes, you are.
He's just
and I'm
finishing up
not
this
going to let you start tomorrow because you weren't honest with me.
Uh-oh.
And when people aren't honest with me, this is what's going to happen, particularly with something that's as serious is going out and committing 4 drunk drivings. You have no idea how lucky you got that they didn't charge you with a felony. I'm sorry, ma'am. Have a seat. That's it. Sorry, guys. Haider Abdul Hussein Hassan, 26D-827-965.
Get ready to have seat.
So that's the case. Preface.
Well,
Sir, come on up to the podium and state your name. Your name?
Ayden Hassan.
You're charged with a DNR fish game violation. They think that you were
too many fish over the
snagging
limit.
or attempting to snag fish on April 9 of 26 at Hurock Park near Arsenal Road in Flat Rock.
Let me pause for a second because I'm guessing that most of you don't know the terms of fishing well enough to understand what the judge is saying. Those of you that do, this makes a lot of sense. But when you're fishing, most places, the ocean is a little different, but most places you're not allowed to snag fish. Snagging fish is where you have a big weight and a hook on it with usually multiple barbs, and you just sort of rip it through the school of fish to try to just catch them by the tail or the face or the belly or wherever. It's really cruel, and it makes it difficult to, if it's not the fish that you're seeking to eat, it lowers their mortality rate considerably. In most states it's illegal to do this, and so this is looked down even among the fishermen who do like catching fish and even eating fish. They look down on this a lot, and they would turn in somebody in a heartbeat that was doing this. So this is what the judge is describing there. It's cheating. The fish isn't trying to eat the hook. It's just ripping a hook through a school of fish and seeing what you can snag, literally.
You have the right to a lawyer. If you want one, I will give you one. You have the right to a lawyer, and if you want one, I will give you one. Would you like one? Sure. Do you understand English good?
Yeah.
Okay. So I'm just explaining the charge to you, and the possible penalties are up to 100 fines, 90 days jail, costs are all those. You tell me if you want a lawyer. If you want one, I will give you one. Today, free of charge, public expense. Would you like a lawyer?
Is it charged in jail?
I'm just telling you, I have to tell you what the maximums are. Those are the maximum penalties. I have to tell you them. I'm not sending you to jail on this. No. I don't usually go out that far, but I'm not gonna send you to jail. You want a lawyer?
Just charge the lawyer.
Okay, so, all right, so we'll proceed and I'll send you to the prosecutor. And if you don't like what he's offering you, you can come back and tell me, Judge, I want a lawyer. Fair enough?
Okay.
Is that fair enough?
Yeah.
All right. Did you sign, read, and understand the advice of rights? Yes?
Yeah, I signed.
If you please, did you read it and understand it?
I really have studies.
You got to keep your voice up for me, nice and loud. Speak into that microphone. I'm getting hard of hearing.
Yeah, I really understand some stuff.
All right. You are presumed innocent. They have to prove you guilty beyond a reasonable doubt. This is a misdemeanor. You have the right to a jury trial. You have the right to.
whose phone is that?
Hello.
You gotta take.
You guys are phone, the signs all over the doors.
Come on, guys. No more phones, please. I don't know what I have to do. Shut your phones off or go out in the hallway and put them in your car or put them in a locker or leave them with a friend, whatever you feel that's the safest. But I cannot have people coming in here with phones every day. All right, listen. You have the right at a trial to remain silent. They can't compel you to testify. You have the right to remain silent. You have the right to testify if you want to. You have the right to bring in your own witnesses that will help you. You have the right to use the subpoena powers of the court, where I will sign an order for you to bring in your own witnesses. You have the right to cross-examine the prosecution's witnesses. If you plead guilty, you're giving up all of those rights. You're waiving the presumption of innocence and the requirement that you're guilty beyond a reasonable doubt. Do you understand?
Yes.
All right. Guys, you still wish to waive your right to a lawyer?
I don't think so.
I can't hear you. I cannot hear you. You got to keep your voice up.
Yeah, so can I explain about
No, you can't explain. This is just an arraignment. You can go explain to the prosecutor. I'll be glad to enter a not guilty plea. And I'm sure the prosecutor is going to be reasonable with you. But if she's not, or you don't think she is, you can come back in here and tell me, Judge, I don't like their offer. I want a lawyer. So do you want to do that? Enter a not guilty plea?
no, so what was the charge like for?
The charge is snagging or attempting to snag a fish. That's what you're charged with.
Okay.
This happened at Hurock Park, according to the police, the DNR officer, on April 9 of 26. That's the charge. Do you want me to give you a lawyer?
No.
All right, I'll enter a not guilty plea. Somehow you posted, it looks like, am I right? He posted a $10 bond. Is that right, Amy?
$10.
Judge, yes, it looks like the conservation fee
Right,
in
right.
there, so he thought that was what he
All
should pay.
So listen, you cannot leave the state without the consent of the court. You cannot violate a law. You must appear in court as directed. I'm going to send you to the prosecutor. You will speak with her. Either way, she's going to send in the file. If you work it out, great. If you don't, and you don't like what they're giving you, then you come in and say, Judge, I want an attorney. Fair enough? Okay? So go out in the hallway. She will call you in. You will talk to her, and then you can decide whether you want to proceed like that. Okay?
Okay.
Thank you.
Thank you.
I'm betting the prosecutor is not going to have much luck talking to him either. I don't think he understands as much as he says he understands. He needs a lawyer, and preferably one that's translated into his language.
Do I have Flat Rock ready over there, guys? People against
Detectives.
Corey William Little, 23B143090.
I cleaned out my...
23F240292. Your name, sir?
Remind me to tell you, I cleaned out my office. Involves some...
He's muted. You have to unmute him, officer. Mr. Westmoreland, your name?
Good morning, Judge. Attorney Corey Westmoreland, appearing on behalf of Mr. Little.
It's still muted.
You adjust the camera, like that helps. Cleaned out my office, got rid of 2 metal detectors. So now I'm down to...
Mr. Little, would you please
5.
state your full name for the record?
Corey William Little.
Okay, officer, your name?
Sergeant Mitchell with Flat Rock
I'm
Police
sorry,
Department.
Sergeant. My apologies. Okay, so defendant still owes a substantial sum of money. He was sentenced by Judge Hessen on the misdemeanor back on July 20 of 23. He was sent a letter in May of 24. Amy, could you tell me how much he owes on each of these, please?
He owes $185 on the case ending in 090 and $399 in the case ending in 292.
What is he going to do here, counsel? I mean,
Yes.
he's had multiple opportunities. I hope he's got the money. It's been going on for 3 years. We've given him chance after chance after chance. If anything, we should be faulted for being so kind. So what is he going to do here?
Your Honor, Mr. Little does acknowledge that he does owe this money to this honorable court. He is a single father of a 2-year-old.
So is he going to plead guilty, or is he going to...
That's correct, Judge. We're prepared
Is
to...
that what you want to do, Mr. Little?
Yes, yeah, that's okay, sir.
If you plead guilty to failure to pay $399, you could get 90 days. Do you understand that?
Yes. I have
I
some.
just
I
want
have
to know
some
if you
money.
understand that. Do you understand?
Yes, sir.
And you
Yes.
also, you said 185 on the other one, right? Is that right? Amy?
Yes,
Why am I getting, why am I
one
getting,
eight. Yes,
why am I getting feedback over there?
It's from Flat Rock's jail, Judge.
Can you tell them to ask them to work on that, please, Sergeant? I mean, I don't like to hear my voice that much.
I will let IT know about it.
If you plead guilty to failure to pay 185, you can get 1 day for every $10 owed. You could get 19 days. You can satisfy that in full by payment, in full by serving the jail term, or in part by payment, and in part by serving the jail term. Do you understand that?
Yes, sir.
Doubly so. I understand. Yes.
Okay. Now, if you plead guilty again, geez, that's driving me crazy. If you paid $85, you'd only owe 100 on the civil infraction. You get $10 credit for each day served. Do you understand that?
Yes, sir.
So you'd only have to serve 10 days. Do you understand that?
Yes, sir.
All right. Now, to the charge that you failed to pay 185 on the civil infraction, how do you plead?
Guilty.
Did you fail to pay?
Yes, sir, I did.
To the charge you failed to pay $3.99 on the drivewall suspend that was revoked, that was reduced to allow an unlicensed driver to drive. How do you plead?
Guilty.
Did you fail to pay on that?
Yes, sir.
Anybody force you to plead guilty or promise you anything to induce you to plead guilty?
No, sir.
Pleas are accepted. You got a big problem here. Judge Hessen was kind with you starting back in November of 23. I was kind with you starting back in July of 23. You hadn't paid. We show cause you. You pled guilty to failure to pay $213. I said you would have paid $30 per week beginning July 23. She's had multiple payment plans set up with you. I told you if you didn't have the money to come talk to me, and here we are 3 years later. I hope you have this money. If you don't, you got a big problem. You have the money?
I have majority.
Mr. Westmoreland, what would you like to say?
Yes, Your Honor. Mr. Little, currently living in Monroe, he is gainfully employed working at True Cuts LLC Lawn Care. He does acknowledge that he owes the money. Like I mentioned earlier, he is a single father.
Just mute the jail.
I would just ask for one last payment plan.
When he says he has a great majority. What is that?
What could you make a payment?
I can pay like 150 at least today.
That's not the great majority. You owe the court $584, and you've had 3 years to pay this. You've been given multiple opportunities.
I could probably come up at least like $200, $300, $400 today. I just don't know exactly what I have. When I was arrested in Monroe County, I had $150 in my pocket. So I'm just saying what I know I for sure have in my pocket.
When are you going to grow up?
Sir, I'm not making excuses. I'm holding 100% accountability. I know I was supposed to pay the money. Honestly, I just completed Monroe County probation back in May of last year, and I take care of a son by myself. I'm currently homeless, and I've been trying to get back in with that. I just want a place to live. I was staying in a hotel for the last 3 months.
Where do you
my
work?
son. So I work at True Cuts LLC.
Who takes care of your son when you're at work?
I have my mom. My mom takes care of him, and then I have like family friends watch him here and there. And then I also have to pay them out of my wages of part-time from that. So it's just I'm trying my best here, sir. I'm not making excuses for it. I know I'm supposed to pay it, but I'm really trying my absolute best. I'm sorry I could have paid at least $10. I could have paid something. You are right about that. And I apologize. My apologies for that. And yeah, I can pay a few dollars. I have $26 on me in my
I thought you said 150.
I thought you said 150. No, when I was arrested in Monroe, I had 150, but my girlfriend was there, and that was the money we were using towards our rent for where we were staying at, so she had grabbed it. But
I thought you said you were homeless.
I am homeless. I told you I just found a little spot to stay at. I literally just found it, and that literally was our first day.
I'm not letting you go
that we were going to pay.
$26. Okay.
Okay, that's understandable.
Sergeant, let them
I'm just saying
make
that's
some
what I have on
calls.
me, but
Have them bring it to the police station. John, text my court officer when he's done that. He has the money there. And I will go out of my way to figure out a way to help him, but he's got to grow up a lot. So you can text John and let him know, and we'll go from there. I told you to come talk to me. I don't understand this. I understand people not having the money. You never gave us the courtesy. You came in front of Judge Heston and apparently gave her a sob story on multiple occasions, and each time she gave you an extension.
This is so bad.
So that's it. Let us know when he's ready. He's got to have a lot more than $26.
Just mute the court already.
No, what's your question?
So say for instance, if someone could come in and pay like the $400 bond that I was supposed
skip
to
ahead.
Have instead of paying that $400.
Okay, good enough. She's moving it. She said defendant got license. People moved to dismiss based on compliance with the law. The fishing without a license is dismissed. Congratulations. Good luck. Make sure you have that next time, okay? Kenneth Paul Joswiak, 26D827908. Your name, sir. I'm sorry?
We got to wait for the other dude to come back.
Hi, your name?
Kenneth Joswiak.
Okay, it says dismissed in the interest of justice.
Do
you have a fishing license?
No, there's no media access.
How's that in the interest of justice? You were fishing without a license, right?
Yes. I just don't have the money to pay the ticket.
Call in.
Here's what I don't like. I don't like this ticket. Now, the snagging fish guy.
Well, you should have thought about that before you fished without a license. Right? Don't you think?
It was the first day of the new license. I had forgotten to re-up it.
Hello?
Hi, good morning.
Can I have Ms. Osmaro in here, please? Thank you. Thank you. Say again?
It was the first day it was the 1st of April, and I didn't renew my license yet. And
so why were you fishing if you hadn't renewed your license?
Got too excited about it.
Ms. Osmaro, your name?
Good morning,
I don't mind if they got a license. That's up to you, but he doesn't have a license. Why is this in the interest of justice?
Your Honor, I did state in the interest of justice while speaking to the defendant in the back. He did mention at this point that he was just asking for maybe to say the word mercy. He doesn't have anyone to pay any of the tickets or be paying. If you want, we can just explain as well. So you see, I guess.
He's either going out. I'm not going to dismiss this unless he goes out and gets himself a license, period. So you're either going to plead responsible here today as charged, or I'll give you 2 weeks to go get a license. If he gets a license, I don't have a problem with dismissal, but I'm not going to just, everybody finds ways, right? I mean, so what is your choice?
License, that's the case.
Do you work?
I do.
Where?
Dollar Dairy.
How much you make there?
$1.50 an hour.
You have kids?
5.
Adjourn 2 weeks. If the defendant gets licensed, no problem.
Thank you, Your Honor.
if I find a way to get it today, I just got back and shelter.
Well, you just told me that you didn't have the money.
Cause I don't.
Go get it now and come back. Go get it now and come back. Go get it now, come back. If that's what you want to do, I'll be glad to dismiss it. If you don't get it today, then I'll be glad to give you 2 weeks to adjourn. It's up to you.
Sorry.
Which is your choice?
I'll make some calls when I leave and I'll go get it today.
Okay, good enough. Come on back. Just try to get back here no later than 11, okay?
Will do, sir. Thank you.
All right, good luck. Dana A. Baker, 25W840758. Thank you.
Good morning, Helen.
Good morning. Your name?
Damon, the big boy.
So you were supposed to pay 50 a month starting January 18th. You didn't pay anything until paid $10 on February 19th and 100 on May 12th.
I just paid 100 just now.
I know.
She let me know.
So why didn't you come and talk to us though? I mean, it's hard for me to give people time to pay when they're already 4 months late. You follow me? I'm going to do it for you, but stop this. That's a bad habit. How much time do you need? I'll be glad to you can set up your own payment plan.
No, $50 a month is good.
Well, do you work, ma'am? Do you work?
Yes.
Where?
At the airport.
How much you make there?
I don't make much.
Well, I don't know what that means. What do you do?
Like I do.
You pay 50 per month, beginning June 1. If you need more time, you call the court. I'll be happy. We can go on Zoom or you can come in here on or before the due date. I'll be glad to give you an extension. Okay?
Instead of $150 a month, can I do 100 every other month? Like I just paid 100 today. So today's date, can I pay another 100 like a month? That makes sense every other month.
I don't care how you do it. You can't pay 50 more by June 1?
I might, but I might not be able to. I'm going to do it.
Right? Tell you what, better to pay 100 bi-monthly. Bi-monthly. Better to pay $100 bi-monthly beginning June the 15th. Okay?
Yes, that's fine.
Now, if you don't have the money, it's not a problem. It really isn't, but you got to call the court and show some respect, all right? And they'll either tell you to come in or you can do it on Zoom if you'd like. I'll be glad to give you an extension. Just don't ignore me, okay? Best of luck to you. Morosco. Richard Joseph Morosco, 26M125988. Morning, sir. Could I have seated up here Dorian Jones? At the table, please. Sir, your name?
Richard Morosco.
Good morning, sir. You're charged with driving over a sidewalk and then...
Yes, sir.
That's what happened in Texas.
It looks like... I can't... Hang on 1 second. I can't quite read this. It looks like he's saying that you didn't change your address.
Oh. Yeah,
So hang on.
Okay.
You have the right to a lawyer. I'll be happy to give you one. Would you like a lawyer?
Tomorrow.
Yes.
Let me give you a lawyer.
Yes.
Okay? I'll give you a lawyer on this. All right?
Okay.
And you can go talk to the lawyer right now, and then you can come back in front of me. All right?
Okay.
Best of luck to you, sir. I wish you well. So go outside into the hallway, and we'll set you up with a lawyer, okay?
Is that for the license?
It's for both. For driving over the sidewalk, and it looks like you're saying, it looks like he's saying you didn't change your address with the Secretary of State.
It's correct.
That might be. Listen, I'm not accusing you of anything. I'm just telling you what the charges are. You go talk to a lawyer. This is not the end of the world. I will have 100 cases worse than this in the next 24 hours. So I just want you to go speak to a lawyer. You're in your 80s, right? So I want to make sure this is done right for you, okay? I'm not trying to scare you or anything else, okay?
I got the right license, though. I got the right license.
You drove over a sidewalk, they think. You're not going to jail. Just relax. I'm just going to give you a lawyer because I want to make sure you're treated fairly, okay? I promise you. All right? Okay, good enough. Thanks. Dorian Darzell Jones, 21M 918849, 26M. I'm sorry, and that's it. Well, your name.
Dorian Darzell Jones.
You were issued this citation in 2021. You didn't show up for your show cause for failure to pay in February of 28. February of 22. February of 22.
Yeah.
So here you come in now, 4 years later, and you're asking for time to pay?
Yes, sir.
I must be out of my mind. No, I must be. I must not just quite understand. Now, I didn't say everybody was wealthy. I don't understand the lack of respect. I don't understand it's somebody ignoring the court for 5 years and then walking in and saying, Judge, I haven't paid a nickel. I want time to pay.
Welcome, Samsung.
I just can't relate to this. But it happens every day, so shame on me. Shame on me. Where do you work at?
I work on hands and strong landscaping.
How many hours do you work?
Depends on the week. It's been real rainy lately, anywhere from 30 to 50 hours.
Why haven't you come in and talked to us since 2021 on this ticket?
Because in the process of me getting the ticket, I was moving, and
Don't tell me you forgot.
no, not that I forgot. I never got the paperwork.
Never got the paperwork. So you didn't think to call the court and say, hey, a police officer wrote me a ticket and he handed it to me on July 13th. I know it wouldn't take you guys 5 years to process it. I got a show cause in 21. How old are you?
I'm 26.
Did you graduate?
Yes, sir.
When are you going to grow up?
Process of doing so now.
I suggest I start now.
How much money do you have today?
I don't have anything today, but I get paid tomorrow and I can make $150 payment tomorrow.
Well, why don't you wait to come in tomorrow?
Because I work tomorrow and I don't want next work.
You married?
Yeah, no, engaged.
Do you have kids?
Yes, sir.
How many?
3.
How much can you afford to pay per week after you pay the $150 tomorrow?
$50 to $100 a week.
I'll make it 30. You pay $100 by May the 13th.
But you have to
Then
pay
you pay 30 per week. Jeez. Beginning May the 22nd, okay?
Okay.
If you need more time, no problem. Call the court. We'll go on Zoom, honor before the due date, or you walk in here, honor before the due date. I'll be happy to give you an extension, okay?
Yes, sir. Thank
Good
you.
luck. Willie A. Hines,
Did I spy a grandfather clock?
26M677859. Is Willie Hines here?
Judge, I have somebody in the breakout room that says Will's phone, not the breakout room, the waiting room that I've been trying to contact to get a name, so he could be here.
Hi.
Okay, can you start your video, please, Mr. Hines? There you are. Good morning. Your name?
Good morning, Willie Hines.
Okay, so you're here.
Give me 1 second.
Hold, please. He says.
I'm sorry. Yes, I'm here. I'm also at work. I'm sorry. I'm stepping out.
Okay.
Okay.
Amy, I thought we were handling civil infractions on our own. Am I wrong?
Samsung's making me dizzy.
I'll talk to you about that.
Oh, we got a puppy? I think a puppy.
Jeez. Do I have Trooper Martin here?
Yes, sir. I'm right here.
Okay. Good morning, Trooper. Your name?
Good morning. Trooper C. Martin, sir.
All right. So he is charged with speeding.
Yes, sir.
11 to 15 over. And you warned him on a seatbelt and improper registration display.
Yes, sir.
Any offer here? He's got a clean record, it looks like.
I can do 1 to 5 over on the freeway for him.
All right. Do you want to do that, Mr. Hines? That would be 0 points, but it would go on your record. It's a limited access, 75 and a 70. Do you want to do that?
Yes, sir. I also wanted to explain what was going on that day. If I can have like a minute just to, just to explain things.
Well, I can't do anything with the charge,
I
but
understand.
I can consider reducing the fines depending on what you're going to tell me. Do you want to
Okay.
plead the 75 and a 70 first?
Yes, sir.
To
Yes,
that
Your Honor.
charge, responsible or not responsible?
75 and a 70.
Responsible or not responsible to
Respo-
75 and a 70?
Responsible.
All right, I'll accept the plea, dismiss the 11 to 15 over. What would you like to tell me?
Okay, Your Honor, I came to Michigan because my sister had a stroke, and I was visiting her. And as I was visiting her, I had to cut it short because I got a phone call. I'm a single dad, 100% single,
We
just
need
me
the
and my
Cliff Notes
boys.
version.
And the mom was taking the boys, the visitation, and I got a call from her stating that she was in an accident. So I left there, and yes, I was driving. I was distraught. When the officer pulled me over,
We're making the
I
bed
was in
now.
tears and crying, and I was trying to explain to him that I was speeding, but I didn't recognize how fast I was going. And when he put me over, he said, "Well, if you can prove to me that your kids was in an accident, I'll give you a warning or whatever." I don't remember exactly what he said. I don't want to quote him. I'm sorry. But I called her up and I said, "Well, can you put the state trooper on the phone so he can speak to the officer so, he'd think that he'll know that I'm not lying." And I guess he had another call or something. When he came back, I went to him on the phone and say, "Here, the state trooper's on the phone." He's
Listen,
like, "Well, I'm
listen.
sorry."
I always charge 150 on these, okay? Because you got a clean record. I'll make it 125. Fair enough?
Yes, Your Honor.
I'll lower the
Thank you
fee
so
if you
much.
just
It was
stop
just a bad
talking.
week. And I
I
did
understand.
actually
Did you
sit there.
get your plate? Did you get your got to wear your seatbelt though, and you got to have your
No, I
I don't
had
know
it
what was
on,
it.
Your Honor. I had it on, but I have a neck injury. So when I don't have it across my chest because sometimes like when I look over and I'm trying to back up, it hurt, it pulls and hurt my neck. But I had it around my waist. But I was
Okay.
showing him I had a
That
paper
doesn't
with a
comply with the
doctor.
law though, sir. You better get a letter from a physician if you don't intend to
I
put the
had one.
show.
I had one, but he was in too much in a rush to see it.
Okay. Well, he didn't write you though. He was nice
Yeah,
enough to not write you
and
and
I
not write you
appreciate
for
that.
improper display. Okay. Can you
Yes,
pay
sir.
this today?
No, sir. I mean, I'm
When can you
struggling
pay?
right
Just
now.
tell me when you can pay it.
Can I how much do I owe total?
125 is all.
Oh, I can pay that Friday.
Okay. I'll give you
Yes.
till Friday. That is the 15th. Okay.
Yes, sir. Thank you, Your Honor. I appreciate it. Officer, I do apologize.
Good luck.
Thank you,
Thank
sir.
you.
All right.
Josh is lining up another pro se case for us in just a second. We want to see how this the rough translation one, the snagging fish, ends
Okay.
up.
How do I get out of this?
He just hang.
You can just
Oh,
yeah, there
I
you
see
go.
it. He's gone. He's gone.
People against Keith James Haddix, 26W710099.
Good morning, Your Honor. Good morning to your staff. May it please the
About
court,
241.
Clint Kesto, P69711, appearing on behalf of the defendant Keith Haddix, who was in the waiting room, but I think he's just been let in, appearing via Zoom with consent. Mr. Haddix, state your name for the court.
James Haddix III.
Don't need to call anybody. I'm sorry. Okay,
Yeah.
so what are we doing? This is an adjournment of the PCC. I'll give you a week, and then we're going to do it the following week, the exam. Okay, counsel?
Your Honor, may I just ask for 2 weeks or a different day besides the 19th?
Let's just set it for exam on the 26th then.
Okay. I just got the video recordings today. Is this in-person exam? Because
Yeah.
if we waive it, I didn't know if the prosecutor needed to call her witnesses or we needed to come down if we're going to waive it.
Okay, can you do it on the 19th by Zoom for the PCC?
Mr. Haddix,
Yeah,
can you
that's
do a Zoom?
Absolutely.
You could do a Zoom next week?
Yeah.
And is that the same time, 9:15, Your Honor?
Yeah, here's what I'll do. You have the right to a probable cause
We're gonna
conference
skip
within
forward a little
14
bit.
days of the date of the arraignment.
We're gonna see if we can find when our fish snagger guy comes back. Let's see, he's not there yet. Is that him? No. Got a lot of people on Zoom.
26.
How about that?
You have one other
That's not
jury
him.
trial.
Let's skip forward. Oh, he gets a jury trial. That's awesome.
To
Is
Mr.
this
Ellis.
him?
Oh.
Mr. Wilkins, I should say.
Okay.
But here comes the situation. We need several weeks over here. He still is waiting for his permanent license in the mail.
That's not him.
Yes, Your Honor.
That's
why
not
then
him. That's the lawyer that always loses in front of him, no matter how hard he tries.
Okay. Okay.
That's not him. He's dressed in a suit. Let's skip forward. That's not
We're
him.
in a
Also in a nice suit.
Sterling Wright file. Just
Does he come back at all, Josh? Looking for our fish snagger. Where's our fish snagger? Must have come back in the last hour. Judge is waiting. Judge is waiting.
at 10 a.m. You show up in front of Judge Hudson.
That's not him. Oh, look, Judge gets good stretch in this.
Okay.
All right. Thank you very much.
Have a good day. Thanks.
You too. Bye-bye.
What's your name, sir?
Serena?
Where you been?
Outside. I talked to the bailiff. He told me to stay outside. And I've been sitting there.
Ah. If you go to a Tiger game, you're going to sit out in the parking lot? Who told you to sit outside?
Man,
The bailiff did.
he told me to wait out in the lobby for a minute.
Can you get that Scarina file?
Sounds good, Selena.
Amy,
Probably just.
can you have Mr. Gonick phoned and tell him Mr. Scarina was sitting out in the hallway?
Do I take this back to you?
He didn't come in.
It back to you.
Yeah.
Scheduled for court, but he doesn't come in. Everyone else goes in. He stays in the hallway because the bailiff said, have a seat. Okay, judge is on break here. Where's our fish snagger?
Did get an email from the Veterans
He doesn't
Treatment
come
Court,
back in?
and it appears that Mr. Scarina may be eligible. So what I would,
If he doesn't come back in.
Don't keep me.
Okay, we're going to jump to another one then. We're going to jump right over here. Got a pro se. James Hunter's here, live from his kitchen. No, I don't know. That's his law office, I think. Judge is here. Judge Lillard. Hello, Judge Lillard. Welcome.
You guys, I apologize. I forgot you were on here, and I took a motion that involved a pro se litigant.
No problem. Good morning, Your Honor.
Good morning. Let me turn up the volume because I have this ear infection, so I can't hear good. Hold on.
Can you hear me now? Can you hear me now? Hello? How about now? Is that any better? Can you hear me now?
I will yell for Your Honors. I will note, I think
I'm good. I can hear now.
Okay. I think Mr. Ryder is muted.
He is. But once I ask to unmute whoever's there to assist you, sir, somebody, is there somebody there to assist you at your facility? They have to do something. You gotta get somebody to come help you.
He has a big stack of papers.
How are you,
So
Judge?
I'm gonna talk to the lawyers on the settlement conference real quick. No, they're gonna take it.
Hello.
Cause this.
She takes off her headphones. No one can talk to the judge.
I think you're good now. You're unmuted. Come back. Oh, what's his name?
Mr. Ryder.
Mr. Ryder, you good? Come back.
You're good. You're good. Love technology.
Can you hear me, Mr. Ryder? Dang, I can't hear him. He not good. We thought he was good. It says unmuted, but we still don't hear him. Seth, can you hear him? It's not me, is it? Mr. Ryder, can you hear me?
I can hear you.
All right, we in business. Madam Clerk, whenever I'm gonna press record. Uh,
We're in business.
is it recorded?
No, it is.
Whenever you're ready, Madam Clerk, please call this case.
Calling case number 25006-269, Ryder versus Pajak.
Your appearances for the record, please.
Good morning, Your Honor. James
She
Hunter
has
on
the
behalf
voice
of
of
the
an
defendant, Christine
airport
Pajak.
announcer.
Good morning. Sir, can you put your appearance on the record?
Good morning, George Ryder.
Hey, George.
All right. You know what? This is gonna take a minute. I'll be right back with you guys.
Judge is like, see ya. See ya. She has the voice
I
of...
don't want y'all to get stuck behind another pro se motion. It's gonna take a minute. That's why I was trying to take you all back, but he went to the bathroom.
The moving sidewalk is for your traveling convenience. Please stand to the right in single file so that others may walk past you on the left. This is...
Is it on another floor?
Your call is very important to us.
No, it's the not
Please
his
remain on
chemo,
your
but the
line,
men's room.
and your call will be
I don't even
answered
think
in the
it's on
order it
this
was
floor.
received.
Okay, well, as soon as he comes back, I'll pause this argument to address your case, okay? Or we could do the swearing in. Where your guy go?
Where's your guy gone?
Oh, he didn't get his paperwork yet? Okay, well, as soon as he comes back, I will pause this argument to take care of you guys, okay?
George is like, you're just going to interrupt me mid soliloquy?
Call me Andy.
Seth.
Go introduce yourself.
Seth, in 10 minutes, page me and say I have an important phone call. That's what she
Notre
said.
Dame Law Class of 2025, my Seth Squire.
There we go.
He from here.
Oh, first degree red rum.
Don't be trying to steal him either. Don't be trying to steal him either. I know how you big law firm people are.
We have a case this afternoon with Judge Boyd. It's a vehicular
All right, I'm
manslaughter.
sorry, gentlemen. Your appearances for the record, please.
We could hear you, Judge, the whole time.
James Hunter on behalf of Christine Pajak.
Good morning, Mr. Hunter.
Good morning.
George Ryder, pro se.
Good morning, Mr. Ryder. Whenever you're ready, you may proceed with your motion.
Good morning, Your Honor. This motion has been filed under C7. Alternatively, in footnotes, there are some references to C8, but I will stick with our main argument, which relates to the application of crossover estoppel to this case. Mr. Ryder has filed a legal malpractice case against his former appellate lawyer, Christine Pajak. This arises out of criminal proceedings that were before Judge Joseph Toya. The underlying issue was a murder conviction and challenging an underlying warrant and search of a cell phone.
I hate to interrupt you, but hold on. Let me take care of these lawyers because one of the parties has to get to a very important doctor's appointment. Okay, so pause right there.
And we know that George doesn't have anything else on his schedule. He can wait. All right, so we now pause for station identification while the judge takes care of any other business, regardless of how pressing it was, before she goes back to this pro se argument. She is not excited to take, because she just had one before this as well. It's like back-to-back pro se. Oh, this is good. Yes, her wall does say all the blick. I'm guessing it's meant the Republic of all the Republic. What state are we in? Looking for signs. Somebody tell me. Michigan? Michigan. Should notice from the flag. Judge Boyd starts this afternoon. Maybe just public. She's got those old school prison cam mounted up on the wall, like I had in school. Black and white cameras. Where's our hold music? We need some music. I'm gonna skip ahead because we can. If we could hear what was happening in the other hearing, we would have listened to it. But where the judge is just out. Oh, here we go. She's back. She's back. Okay, you got your papers in order, George? Because here we go. She's got a cup of coffee. She's got an ice cream cone in one hand. She's like, sorry that the bus was running late.
Okay, I'm back, gentlemen. I apologize. Mr. Hunter, you had just begun your oral argument. You may continue.
No problem, Your Honor. So this is a legal malpractice case filed by Mr. Ryder against his former appellate counsel, Christine Patrick. We, of course, rely on our briefs, and I think everything is pretty much set out in detail there. The main issue here, this is an underlying criminal matter before Judge Toya. The predominant issue that Mr. Ryder raises. Well, I'll give you some additional background.
I read these things, and I understand that your argument is that there's already been appellate litigation that found that there was no ineffective assistance of counsel. And in essence, you're arguing that because she was deemed in the criminal court not to have been ineffective, that bars, as a matter of collateral estoppel, the plaintiff for now suing for malpractice.
That is 100% correct. That's the main thrust of the argument, Your Honor. The main issue that Mr. Ryder raises in the complaint and in response is this idea of an affidavit missing by a detective. There appears, based on Judge Toya's...
Detective Bozek?
Yes, and Judge Toya addressed this, and Mr. Ryder addressed this in the underlying case. Mr. Ryder's theory is that this should also have been raised on appeal. The problem is that the purported affidavit appears to be testimony by Detective Bozek in the underlying case, and it related to an arrest warrant, not a search warrant. And Judge Toya noted that for the arrest warrant, that type of affidavit is not required, and one did not exist in this case at all. So not only do we have the crossover estoppel issue, but we have just basically on a C8 basis, attorney judgment rule. There's no breach and no duty for an attorney to raise what would be a meritless argument. And so we also have that supporting our position in this case. But this is a clear-cut application of defensive estoppel, which is absolutely permissible in legal malpractice cases arising from underlying criminal representation. In this case, the appellate proceeding, which, by the way, I will note, Ms. Patrick was successful in the appellate process in obtaining, some challenges to evidentiary issues that existed in the underlying trial. So it actually went back for an evidentiary hearing, then went back up on appeal. Ms. Patrick did a great job. The issues raised by Mr. Ryder are not actionable here. They were already litigated fully in the underlying case, and therefore the application of estoppel here is proper, and the case should be dismissed. Of course, Your Honor, I understand you've read everything, and I'm happy to address any other substantive questions you may have.
I don't have any. Thank you, Mr. Hunter. Your response?
Yes, I'm not a lawyer, and he done a wonderful job representing his client. But I'm sitting here wrongfully convicted. There's no written complaint in this case. There's no affidavit. There's no oath. There's nothing for arrest warrant. As I sit here today, and it's impossible to have an arrest warrant without a written complaint. And with Christine Pajak being my appellate attorney, the appellate attorney is supposed to master the records and find anything dealing with arrest warrant. So if Detective Bozak did not have an affidavit, he should at least had a written complaint. It's not even a prosecutor's authorization for arrest warrant. These are things that's required to get arrest warrant. So I just want to put that on the record. You read my motion, and it speaks to all of that.
Okay, is there anything else you'd like to tell me, sir?
I'm wrongfully convicted, and Christine Pajak was negligent in handling my direct appeal. She argued the Fourth Amendment to the search, but she neglected to argue my arrest. That's all I got to say.
Okay, thank you. Mr. Hunter, do you have any rebuttal that you wish to make at this time?
No, Your Honor, and look, I understand Mr. Ryder's concerns. However, these were all raised extensively in the underlying case. I've reviewed the materials from the underlying case, the issue of the alleged affidavit, the arrest warrant. There was a Ginther hearing. There was multiple hearings, Frank's hearing, I believe, as well. I understand Mr. Ryder's contention that he is wrongfully convicted. Even if that were the case, that would have no bearing on liability as to Ms. Patrick.
All right, thank you. This is a legal malpractice action that arises from defendant Christine A. Pajak's prior representation of plaintiff George Gerald Ryder in connection with his criminal appeal and related post-remand proceedings. The plaintiff alleges that defendant committed legal malpractice by failing to obtain, investigate, or raise issues concerning an alleged oath or affidavit by Detective Daniel Bozek in connection with plaintiff's arrest warrant. Plaintiff contends that this alleged failure caused or contributed to his continued conviction and imprisonment. The defendant has moved this court for summary disposition on two grounds. First, the defendant argues that summary disposition is required under MCR 2.116C3 because plaintiff failed to properly serve her with both the summons and complaint. The defendant avers that she received only the summons and never received the complaint by certified mail, email, or any other method. The defendant further asserts that her counsel obtained the complaint independently and that plaintiff's attempted service did not satisfy MCR 2.105 subsection A.
The judge
Second,
prepared this
the
one
defendant
earlier.
argues that plaintiff's malpractice
Oh, someone's in my courtroom.
You ready? Okay. You got to give her something, right?
She's ready for
Did
any
Seth know how to
interruption.
make the certificates? Can you ask Seth to make a certificate? Okay. It's here, but we got to make a certificate for you, so just have a seat, okay? Second, defendant argues that plaintiff's malpractice claim is barred under MCR 2.116C7 by collateral estoppel, sometimes referred to in this context as crossover estoppel. Defendant contends that plaintiff already raised the same underlying issues in his criminal and post-conviction proceedings, including allegations that defendant was ineffective for failing to raise issues concerning Detective Bozek's testimony, oath, affidavit, and alleged prosecutorial misconduct. The defendant relies primarily on the Macomb County Circuit Court September 26, 2024 opinion and October 31, 2024 order denying reconsideration in which Judge Joseph Toya rejected plaintiff's ineffective assistance arguments. Plaintiff, proceeding in propria persona, opposes summary disposition. As to service, plaintiff contends that he made good faith efforts to serve defendant despite the limitations imposed by his incarceration. Plaintiff relies on an affidavit from Tammy Talley, which states that mailings were sent to addresses associated with the defendant. Plaintiff also asserts that the mail was not returned as undeliverable and that the complaint was sent to an email address he believed was associated with defendant. As to preclusion, the plaintiff argues that his malpractice claim is not barred because his civil malpractice claims involves different interests and issues than the prior criminal proceeding. He also maintains that Detective Bozek's oath or affidavit exists and that defendant negligently failed to obtain or use it. The plaintiff relies on a February 22nd, 2017 transcript in which Detective Bozek was sworn before a district judge and gave testimony in support of warrant authorization. The defendant's dispositive argument is that plaintiff's malpractice claim is barred by collateral estoppel because the same attorney performance and causation issues were already litigated and decided in plaintiff's criminal proceedings. A motion under MCR 2.116C7 tests whether a claim is barred as a matter of law, including by prior judgment or collateral estoppel. MCR 2.116C7. In deciding a motion under C7, the court must accept the well-pleaded allegations in the complaint as true, unless contradicted by documentary evidence which the court may consider. And that's from Mason v. Roswell, which is 461 Mich 109 at page 119, a 1999 case. Collateral estoppel bars relitigation of an issue in a subsequent action where the issue was actually litigated and necessarily determined in a prior proceeding. The prior proceeding resulted in a valid final judgment, and the party against whom estoppel is asserted had a full and fair opportunity to litigate the issue. Mutuality is not required when collateral estoppel is asserted defensively, provided the party to be estopped had a full and fair opportunity to litigate. And that's Monad v. State Farm Insurance Company, which is 469 Mich 679 at page 691 through 692, a 2004 case. Michigan courts have applied collateral estoppel in legal malpractice cases arising from criminal proceedings. In Knobloch versus Kenyon, 163 Mishap 712, a 1987 case, the Court of Appeals held that the legal standards for ineffective assistance of counsel in criminal proceedings and legal malpractice in civil proceedings are equivalent for the purposes of collateral estoppel. Similarly, in Barrow versus Pritchard, which is 235 Mishap 478, a 1999 case, the Court of Appeals held that where a criminal court has fully and fairly determined that a client received effective assistance of counsel, the attorney may defensively assert collateral estoppel in a later malpractice action. There, the court held that a criminal defendant's unsuccessful ineffective assistance claim barred a later legal malpractice action based on the same alleged attorney errors. The court reasoned that the Strickland performance prong corresponds to the breach element of malpractice, and the Strickland prejudice prong corresponds to the causation element of malpractice. However, collateral estoppel applies only to issues actually litigated and necessarily decided. In Schulman versus Terrence J. O. Hagan, PC, which is 173 Mishap 345, a 1988 case, the Court of Appeals recognized that collateral estoppel may bar malpractice claims based on attorney negligence where ineffective assistance has already been decided, but it does not necessarily bar distinct claims such as breach of contract, breach of fiduciary duty, or fraudulent misrepresentation if those issues were not actually decided in a criminal proceeding.
She's laying it on
The
thick.
record submitted by defendant indicates that plaintiff previously raised ineffective assistance arguments against defendant Pajak in post-conviction proceedings. Those arguments included claims that defendant failed to raise prosecutorial misconduct and failed to pursue issues concerning Detective Bozek's testimony, oath, or affidavit. Judge Toya rejected those arguments in a September 26, 2024 opinion, specifically finding that appellate counsel was not ineffective for failing to raise prosecutorial misconduct based on the prosecution's alleged failure to disclose Detective Bozek's testimony. Judge,
I guess George is going to sit back there and is like, I guess you missed the point where at the beginning where I said I'm not a lawyer.
Concerning Detective Bozek and the alleged affidavit. Those prior rulings, which are final determinations of the ineffective assistant issues, are significant because plaintiff's malpractice claims rest on the same factual predicate that defendant Pajak should have obtained, investigated, or
to see if he has
raised
something
Detective.
else. If he says this is a lot of legal mumbo jumbo, case law, everything else. Let's see if he changes his stance.
Litigating attorney performance and causation issues already decided against.
This will teach him never to file a pro se motion again.
Stated on the record. Your motion is granted. Have a good day, gentlemen.
Thank you, Your Honor.
Kim, do you know why there's more people in the waiting room?
We'll get that submitted today. Thank you all.
Okay, thank you. Hold on, I can't hear you. I don't know why I think I can hear.
This is why you don't argue with lawyers. This is part of the punishment. That is a lot. That is a lot of laying down the law.
They need me? About language in an order? Is it my order? Okay, let me deal with this and then I'll they waiting, so let me deal with them and then I'll figure that out. Come on up.
Okay, we're gonna.
You know it's on YouTube. You tell your family to turn on the YouTube.
Oh, no, I'm in Ohio.
Oh, so they not hype.
Yeah, it's not.
This old hat. Okay.
You know it's on YouTube. Yeah, and she
Anthony.
Let's see what Judge Boyd is doing today.
No, it's Loera. Loera?
Loretta.
Loretta?
Loretta.
Loretto.
Okay.
Announce every vowel.
Every vowel, every letter talks. Hello.
Hello. Good afternoon.
Good afternoon. Okay, so on this case, Odyssey is
She's in a
moving a
good mood.
little bit slow.
I have yet to receive any discovery out of Axon yet, Judge. So I have an appointment letter, and that's about it.
At some point, Exxon and Odyssey is going to ask for representation because people keep blaming them for things. All right, so Norma, I need a discovery date. 45 days.
June 25th.
45
All
days
right,
out.
and state
Yes, Judge.
on Anthony Loretta. Yes.
Anthony
You said
L.
June what date?
25th. Judge.
All right, June 25th. Will you all be prepared to tender an offer at that time?
Yes, Judge.
All right, thank you. All right, once you sign the reset form, you excuse.
Thank you, Judge. Let's see.
All right, who's next?
Taylor, page 7, one down.
Taylor.
Very good. Morning, Judge.
Good morning.
Judge, I can't believe my phone's ringing. Can I get that?
That's okay. So where are we on discovery?
I have read their file. My file kind of reflects the same. There's no videos. We have conferred. They have made us an offer. We have made a counter.
Okay. All right, Ms. Ferguson,
Yes, ma'am.
I need a plea deadline date in 45 days.
June 25th.
All right, so at that time, if you all have not reached an agreement, your next setting will be a jury trial date after that date.
What was the date, June?
June 25th.
That's right after Father's Day, Judge. I'm sorry. I'm not available. Thank you.
All right, you're welcome. You're welcome. Who's
Knew he was
next?
joking.
Another page, it's Raven.
First of all, are they ready on Hernandez?
I think we're still talking, Judge.
All right. And what page is Reyes on?
He's on page 3, one down. Mr. Reyes?
I'm gonna email you because I've got
Probation, this is an application. Mr. Reyes.
Morning, Mom.
Good morning.
That's fine right there.
Court is calling 2025 CR 013280 State versus Tancelado Reyes. Can I have parties announced?
Brandon Brandon for the state.
Joseph Appelt for the defense.
And are you Mr. Reyes? You say yes or no?
Yes, ma'am, and no, ma'am. There you go.
Okay, thank you. Counsel, have you received all discovery? Did you review it with your client?
Yes, I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Reyes, did you review the application for community supervision with your attorney? Did you understand it and sign it?
No.
Did you review
No.
the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading?
We do, Your Honor.
State proceeding as presented?
We are good.
Mr. Reyes, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Thanks.
All right. You're charged with possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea on this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe so, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe so.
Mr. Reyes, has anyone threatened you, coerced you, or placed you in fear? Anyone promised you anything other than the plea? Satisfied with the way you've been represented?
No.
If you're not a U.S. citizen by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
No.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand that?
No.
According to the plea, punishment is to be assessed at 2 years in the state jail facility. There's a $1,000 fine, and the state recommends community supervision. Did you understand that to be your plea? State defense?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By citing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Any such motions?
There are no such motions, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 2 years. There be 100 hours of community service restitution, the DOEP course, and regular UAs. Did you understand those were recommendations from the state, and the court does not have to follow those recommendations?
No.
Then to the offense, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Judge Roberts, exhibit number 1, including all attachments.
And defense has no objection, Your Honor.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Okay.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Okay.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same.
Oh.
The court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Off the record for a moment.
Yes, to go off the record. Judge is in a good mood. I'm going to go check with Judge Oakley.
Endangered himself or others. Domestic violence charge. Domestic violence charge, and there's no history. Domestic violence charge, we've been out there 56 times to that same address in the last 6 months.
56?
Okay. He doesn't listen, right?
In this particular instance, we have information that that day, plus to the entire incident, was on Doorbell. And that basically says that he was hanging out in the area and was waiting for her to come out of the house. It's kind of, how it correlates and everything like that. I think it was 4 months prior, he went over there, basically caused an issue. He ran from us, had a gun on him, stolen gun then, stolen gun this time. Pretty much told me that he was unemployed. I didn't know his phone number and so on. And then magically, the court or the attorney, he's like, oh no, he's employed. And then another thing with the that was conflicting is he told his attorney that he was going through child custody. However, this was over the fact that he
he's not showing up for custody hearings.
Yeah, he basically got kicked out, or the case got dismissed because he wasn't doing what the judge told him to do.
Okay.
So, and typically, like sometimes our bond recommendation, we can't fit everything on there.
Right. And here's the biggest problem though, is when the guy with all the information is not the guy standing there for the arraignment.
I was
so
there.
Here's what I would suggest. If that, and I'm doing 20/20 hindsight.
100%.
At that point, if you're standing there and you're hearing the attorney tell the judge all this stuff, you say, Judge, if I might, and you can say, Judge, I know the attorney says he's got a job, but he told me he was unemployed. Okay. I know the attorney says he's got a child custody
tried
case
to go
going,
through, yeah.
but my information is that that case ended because he wouldn't do what the judge told him to do. So that's the end of the story. So, we'll give you a chance to rebuttal,
Okay.
right?
All right. Because this one, it was kind of only the bond rec and then talk to the attorney.
Mhm.
And then it went straight into kind of just basically handed out the disposition for the bond. And it was like kind of like a goodbye, you know, at the end of it, as far as everything was done. And like, I didn't want to interrupt the attorney. I didn't
Right.
want to interrupt the judge,
Right.
you know, and, you know,
Well,
and I felt like it was already after the fact to kind of say anything. The judge had, you know, kind of already made the ruling on it.
yeah.
So that's where it's kind of tough. Like, I guess that's where I'm trying to
I
get.
think with the three of us up here, I don't think any of us are gonna like get our nose bent out of shape. If you say, Judge, could I interrupt for a minute?
Okay.
Because I've got information to share. The other thing you might do is in a situation like that where you've got a bunch of information and you're just trying to put the highlights on, maybe put a comment on the bond rec. You know, we've got a long history on this case. I'm just giving the highlights. I'd be happy to answer questions or share more information.
Okay. Yeah, throw that on there as far as almost like not even list something, but put on there. You know, I'll discuss the multiple issues at.
Yeah, or say, you know, department requested cash bond, and I'd like to get into it on the record instead of trying to put it all on paper.
Okay.
That just gives us a heads up because none of us are like averse to a cash bond. We just want to have something to hang our hat on. So I think that's a good way to do it.
Okay.
Yeah.
All right. Because like I said, I know.
Because we appreciate it when the guy with the info is standing there, because usually it's, well, you know, usually it's not. Usually it's just, I don't know, Judge, I'm not the detective. Okay.
Yeah. Yeah, well, and I actually called Grayson, the detective on the case, because I was like, hey, I might need you, you know,
right,
how it goes and everything
right.
like that. And then, yeah.
But you had all the personal knowledge you could share yourself. Yeah.
That, but there was also more that he knows. Just apparently there was some Instagram post or something like that. I don't know what they all entail.
Okay.
I didn't get into it. And I was like, hey, you might have to, you know, speak up and,
right.
you know, give the.
Well, I like the idea of putting something on the bond rec that says, you know, or do something out of the ordinary, right? Because this was an out of the ordinary case.
Yeah.
It'd be out of the ordinary for us to see on a bond rec. The department strongly opposes any kind of personal bond, and I've got lots of information I'd like to share on the record when it's time.
Okay.
Okay.
Yeah, yeah.
That's not the normal case.
Right, right. Okay.
Yeah, and the other thing is, you know, the horse is out of the barn, but talk to the prosecutor. And I don't know, is it going to be Kaplan or is it going to be Lecky?
I don't know who's going to be it. If DV relationships, it'll probably be Lecky, is what I would.
Well, if it's a dating relationship, it should be Lecky.
Yes.
So just catch him today and say, look, this arraignment didn't go the way we wanted it to. I had more information I didn't get a chance to share, but I want you to know if there comes a chance to make a bond argument, I've got blah, 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 blah. Just kind of spit it all out for them.
Right, right.
Yeah.
Okay. So I know they're resubmitting for whatever reason. The prosecutor denied. I think they didn't include originally on the November, October case, whichever one that was. I forget the month.
Okay.
They didn't submit, you know, who the gun belonged to or something to register. Or,
yeah.
So
the other thing you need to let Lecky know what's going on with all this backstory information is because at some point Lecky something might happen, and like they arraign him on this new charge, right?
Yeah.
And at some point the defense attorneys would say, well, Judge, you know, he's got a personal bond on the underlying case. Lecky could say, Judge, he's got a personal bond, but there was information that the department had that didn't get shared that day. It was relevant then, it just didn't get shared.
But we didn't get a personal bond, but it was
still wasn't what you wanted.
Yeah, it was low. He was able to post that day.
Right. So in essence, he's out. That's what you're worried about.
Yes.
So I would definitely talk to Lecky about that. Let him know, hey, if you get a chance to make an argument to get this guy's bond increase, here's what's going on.
Okay. All right. Yeah. Perfect. Thank you very much.
Oh, no problem. No problem.
So, all right. Have a good day.
You too.
Wow. Now you know how to do it in the future.
Emily, do you have that?
Officer.
Is that the file in front of you? You still got it? That's all right. That's all right. I'm not rushing you. Just when you're ready. I just want to make sure we had a file when it was time to sentence.
I'll bring him out, Judge.
We'll be ready for him.
Here we go. We got somebody. We'll be going to Judge
Will we be able to get him on the
Boyd
phone?
For court later this afternoon.
They just call it number. we're gonna see if they could get him a phone back here, but if not, I'm in contact with the sergeant of the jail, like you get.
Okay.
They were sort of Van Buren, just taking him to Van Buren first, if they folks there.
Okay. Okay. All right. So our guys are working on it.
Yeah.
Okay. All right. Have a seat, Mr. Houchley. Back on the record, counsel, with your appearance, please.
That's the number 52-107 on behalf of Mr. Housley, who is my left, who is saying third big Housley charge.
Thank you. All right, Mr. Rowley, you had a chance to talk to Mr. Houchley? Okay. Recommendation for sentence?
Probation is 18 months probation, 10 days on the work program. Dual diagnosis treatment within 21 days. If he does need some more time, I can work with him. And then minimum of 3 times for testing.
All right, so 18 months, 10 days. What was the evaluation? Give me that again.
A dual diagnosis of treatment mental.
Mm-hmm. All right. Counsel, your turn.
Here, I think that's right. And kind of as we've discussed, the main goal here is to get some sort of treatment.
Yeah.
And it's something that Mr. Ashley told me off that immediately that that's what he's looking for and that's what he's interested in. And so I do think that 21 days would certainly give him more than enough time to get enrolled in any kind of treatment as needed. I'm not sure.
Let me stop you. I'm sorry, but we're not ordering treatment. We're ordering an evaluation. So, assuming the evaluations recommend treatment, then that'll be ordered. Understood? Okay. All right. Go ahead. I just wanted that clarification.
Thank you. Appreciate that. And I'm done. I don't know what your report's work program entails, but I think if you think that's something that would be beneficial, I think that would be beneficial. These are all things that I think
Yeah. Yeah. Let me do this. Work program is an alternative to jail for me. All right. I'd rather see you in treatment. So here's what I'll do. I'm going to suspend the work program just like I would suspend jail. If you are in treatment, and I'm talking about like inpatient treatment, then let me know. If you're in treatment for 10 days, I'm going to figure that's work program. You got it? Because I'd much rather have you on the inpatient track than
that's a good deal.
The jail or alternative track. Okay? All right. Anything else, counsel? All right. So I'm going to do 18 months probation.
Okay.
When's the last time you had a job?
I've been working off the books for Elf Roofing for the last year.
Okay.
But I've been like, he's still the boss that's probably best friends since they were kids. So he gets to share his job.
Yeah, sure. Okay.
Plus, depending on weather. But once I get my tickets in order for my license, I can go back to being a union carpenter.
Okay. Good money. Yeah, good money. So what's the status with your drivers?
Several tickets, I just have to pay them.
Get them
And
fixed.
So the juggling of the pay versus being able to
Yep.
ride with my daughter.
Any idea what it costs to get your license back?
It's roughly $12,000. But the summer is coming, the
Yeah.
hot season, and for me to do that, I can probably do that within the 2 months
Okay.
coming.
All right, but understand where my head is, and I hope your head is the same place. The first thing is to get you treated, get you healthy, get you clean, right?
Let's jump to
'Cause
another
everything
court
else
really quickly.
is better
Ready?
after that. Okay, so as much as you want to make money and get your license
Let's
back.
jump to this.
Since you've reapplied, we should adjourn this to give time for you to get that attorney, hopefully, right? If they deny you again, you got to make a decision. Do I want to spend money on a lawyer? Can I afford a lawyer? Maybe try and find out how much lawyers cost. But let's get you.
Oh, we ain't working? Oh, yeah, you'll have one, yeah. Oh.
See, what date shall we give it?
I have May 26th at 10.
May 26th.
Can I ask a question
What?
before you say the time?
Lemon car.
I work like 12 hours a day, 11 to 11. Can it be somewhere?
So you want to come like first thing in the morning or
Late
last?
at night.
I don't know what you say, 11 p.m. to 11 a.m. You want to come in the afternoon?
I work from PM to AM.
So you want to come in the afternoon?
I I just want to not have to call in.
Sure. So after 11 a.m. is better. Okay.
Something like
I think he's saying you would like the afternoon.
And that's what I'm trying to get from you.
Yeah, I'm sorry, I'm sleepy.
The latest we can do that day is 2:30. 2:30, May 26th, 2:30.
Yeah.
All right, let's get him a court notice for 2:30 afternoon time. Then remember to set your alarm so that when you come home from work, when you go to sleep, that you remember to wake up and come to court.
I've been here.
Oh, I know.
trying to put this
But
behind me.
I've had other night shift workers who say, I went home, I fell asleep, and I didn't set an alarm, and then I slept through court.
I just don't go to sleep.
No.
Come in.
You have to sleep.
Just come right here and sleep in the lobby for a bit.
I would.
We have that sometimes too.
Before I miss the court.
I don't want you to miss court, but I also don't want you to go without sleep.
Yeah, real quick, what's that come back?
1:15.
1:15.
Do you see your client, Mr. Weedle, in the lobby or in the hallway? Do you want to call Mr. Weedle and ask him if he's coming?
Yeah, I know I have mine this week.
Well, he was Taylor's, but now he's yours.
Yeah, not everything got assigned to me. That's the problem. I think not everything. It's only been 2 business days. 1.
What's the worst?
That's it. That's all we get. That's where it stopped.
Council, are we ready on Cox?
You have to sleep.
What are we
though.
doing?
Yes, just tell them.
Can't just not sleep. This afternoon we'll be in Judge Boyd's court as she has a jury
All right,
trial
appearances
starting.
on the People versus Joseph Cox, please.
Morning, that is at 12:85:689. On behalf of Mr. Thomas, can you pass, please, your name to the record, please?
That's just, Joseph Cox. Thank you. Go ahead.
Today's the date of your time set for the examination. It is now 12:08 by this court's clock. We did send subpoenas. The complaining witness initially stated to our office last month that she was not willing to proceed. However, we served her, or the officer in charge named Toilet served her on Thursday this week. It was last week. And she indicated that she was coming. However, it is 12. Subpoena was for 11:30. It's past half hour and she's not here, therefore we can promise.
Council? All right, did you post any cash? All right. 90% of that gets back to you. Anything else?
Judge, is he the one that, is there a big posted that says that he posted by credit card? We don't have the funds yet, so we can't do anything. When they.
Oh, yeah, it is. It is. Understand that?
We don't-
You posted the bond on credit card, so we don't actually have money to give you back yet. But at some point when that comes through, we're gonna return 90%. What's that? I don't know.
It's all my figure.
All right. Okay, good luck. Council, can you approach on something else? You're welcome. You.
I have
Sorry, that wasn't very
$8.50
clear.
balance in Utah's court system
talked
exchange.
To, Nippus and Romulus.
Number.
And so, yeah.
Just be done.
Yeah, just shut it down. I just talked to Nippus and Romulus. I didn't get the defendant's name.
Spent 20 cents. Did not search the right number. Let's try it again. District and Justice. We'll search both. Last name Richens. First name Corey. Search. Spent another 20 cents. And got some results. Let's see here. We have a couple options. Does anyone know the case number for the Rich and stuff? I can download it real quick. We've got some stuff where she's a petitioner. That's not it. It's going to be the earlier case, I believe. You can do tab. Oh, it doesn't let me do that. Let me use my internet to find it. Okay, 231-500-139. Just one second. Shelly Small says, tomorrow my granddaughter has to go in front of the grand jury to testify against her ex for telecommunications harassment. I'll let you know how it goes. Wow. Wow, that sounds crazy. 231. It's not even one of the options. See if I can type it in here. Let's do a new search. Clear search fields and just go with 2315. There it is. 2315-00139. All right. Found it. View the documents. All right, we might have a document to read before the sentencing tomorrow, but you guys are watching that, which is no fun. You can go here instead. We wait for Thurston County to show up. It's loading because it has a lot of documents here. Hang on. Still loading documents in Corey's case. Is Michael Villian Jr., is he wearing a Cletus McFarland shirt? The YouTuber? All right. Docket's up. Let's see what we can find here in the latest and greatest. You said something was filed on the 8th. Information. Oh, hang on. That's 2023. I need to go down to the bottom. Scrolling. Still scrolling. Over 900 documents here. 1,000 now. 1,200. 1,300. 1,400. 1,500. 1,600. 1,700. Okay, 1,700.
Just got it's got some on Vanderbilt.
3 things were filed today. The state sentencing memorandum. I think that's the one we want. Let's buy that one. I'll buy that for $1.
You can be seated.
Ms. Kamari.
Your Honor, good morning. I'm ready with Nathaniel Vandergriff on the 8:30 calendar. He'll be resolving today.
I don't see a plea form in the.
I just got sent over like 10 seconds ago.
Okay, we do have a document to read with Corey.
So you're
Richards.
Nathaniel Vandergriff?
Yes, sir.
I'm looking at a statement of defendant on plea of guilty, which tells me you're pleading guilty to one count of unlawful possession of a controlled substance. That's your understanding of what's happening?
Yes.
Do you understand when you plead guilty, you give up all the rights contained in paragraph 5 of your plea form?
Yes.
Maximum you can receive is 90 days in jail and a $1,000 fine. Looks like city's just requesting 5 days of electrical monitoring and close the case and give you credit for 1 day served. Is that your understanding of what the city's recommending?
It is.
Do you understand I'm not required to follow that recommendation?
Yes, I know that.
Anybody make any threats or promises other than what's contained in the plea recommendation to get you to plead guilty?
No, sir.
Did you review this whole plea form with your attorney there, Ms. Kamari?
Yes, I did.
Any questions about any of it?
The only question I got is, how long do I actually have to get it hooked up?
I can give you 30 days.
Okay. Right on. Yeah, that works.
Paragraph 11 of your plea form says, on or about April 10th, 2026, in the city of Lacey, you unlawfully possessed a controlled substance. Is that true?
Yes, it is.
And you went through this entire contract or this entire plea form with your attorney?
Yes, I did.
I'll accept your plea, enter a finding of guilty, enter a finding the plea was made knowingly and voluntarily. We'll proceed with sentencing. Anything further from the city?
None.
Ms. Kamari?
Your Honor, we'd ask that you follow the agreed upon recommendation.
Anything you'd like to say, Mr. Vandergriff?
No, sir.
Be 90 days in jail or 5 days in jail, none suspended, credit for 1 day served. You have 4 days left to do, which can be done on electrical monitoring. Get that started by June 12th. And this case will be closed out after that. Good luck going forward.
Thank you, sir. I appreciate it.
You can get a copy of this off the district court website, which you'll probably need to start your EHM.
Home confinement. That's
Okay.
where you're going to go.
All right.
All right.
All right. Thank you.
Thank you.
You may go.
All right.
All right. We've got a document from Corey Richards that we have to read here. This is a sentencing memorandum that was just filed yesterday by the state. Let's see if I can read this to you here. On Valentine's Day 2022, Corey Darden Richards tried and failed to murder her husband and the father of her 3 young children, which is the same. I would say tried and failed to murder her husband and father of her 3 young children, Eric Richards. It sounds like there were 2 people here, where they say and the. Anyway, over the next 17 days, she did not think, what have I done? Rather, she thought, how can I do better? And she murdered Eric in the presence of her, and then she murdered Eric in the presence of their children using poison and for money. Such a person should never again lurk among the rest of us. Her husband should never worry. Her children should never worry that they may one day encounter her. Accordingly, the state requests that the court impose a sentence of life in prison without parole. Corey Richards has earned it. Her children deserve it. Only this court can order it. Oh, I like that. State sentencing request. Number 1, count 1, aggravated murder. Court should order the defendant to serve life in prison without parole. That's LWOP. Count 2, attempted aggravated murder. Court should order the defendant to serve 5 years to life in prison consecutive to any other sentence. Count 3, insurance fraud. The court should order the defendant to serve 1 to 15 years in prison consecutive to any other sentence. Count 4, insurance fraud, the court should order the defendant to serve 1 to 15 years in prison, consecutive to any other sentence. Count 5, forgery, the court should order the defendant to serve 1 to 5 years in prison, consecutive to any other sentence. I think some of these are actually going to go concurrent. Count 6, the court should enter a continuous protective order in favor of Eric Richens' family members that prohibits the defendant from contacting them unless they first initiate contact, and prohibits her from maintaining or benefiting from insurance on the lives of CR, AR, and WR. Eric Richens' family members include CR, AR, and WR. Gene Richens, Katie Richens Benson, Clint Benson, MB and LB, and Amy Richens and Andrew Swenson. The court should order the defendant to pay restitution to Auto Owners Insurance Company in the amount of $1 million, million with the pinky, $1,017,018.49 to be exact. The True Stage Insurance Company in the amount of $352,562.61. The court should order the defendant to pay recoupment to Summit County in the amount of $1,391,943.98. That's a big number. Holy cow. They get the most money. That's how much it costs to prosecute. When sentencing, the court is to weigh and consider several public safety, punishment, deterrence, incapacitation, restitution, and rehabilitation. State v. Klein, case law. For consecutive versus concurrent sentencing decisions, the court must consider the gravity of the circumstances of the offenses, the number of victims, and the history, the character, and rehabilitative needs of the defendant. And also more case law about the sentence in the criminal case should be appropriate for the defendant in the light of his background, hers in this case, and the crime committed also to serve the interests of the society which underlie the criminal justice system. The court is to examine both aggravating and mitigating factors to include the nature and circumstances of the crime, the defendant's character, background, history, mental and physical condition, the impact of the crime on the victim's family and community, and any other facts in aggravation or mitigation of the penalty. Not all aggravating and mitigating factors are equally important, and one factor in mitigation or aggravation may weigh more than several factors on the opposite scale. So it's not a add up how many good points and how many bad points and just cross off until you see who has some left over. It's not a one for one. Pennies add up for sure. The psychological reality is that aggravating circumstances. Why did that do that? Okay, never mind. Aggravating circumstances in the first-degree murder cases will virtually always outweigh or be more compelling than the mitigating circumstances because the commission of capital homicide is an intentional murder, is one of the most heinous acts known to society. The sheer emotional impact of all the evidence of an unjustified killing tends to overwhelm evidence of mitigating factors in the mind of the sentencing authority. The court is to order the totality of the circumstances in imposing a sentence that is proportionate to the crime and the culpability of the defendant. I had a sneeze sneak up on me, and it cannot be avoided. The court is not limited to the circumstances of the crimes for which the defendant has been convicted, but may consider other factors as well. Evidence that is inadmissible at the guilt stage may be admissible for the purpose of sentencing. That's why we get to hear some things like victim impact statements, which are not appropriate for the jury to hear when they're determining if she's guilty or not, but just fine for the judge or the jury to hear, and if it's a jury state, to determine the sentencing. Let's see. Such information must be reasonably reliable and relevant. And the case law here, the state took the death penalty off the table in the early days of this case. Notice of intent to not seek the death penalty was filed. Accordingly, on count 1, the court must sentence the defendant to either life without parole or an indeterminate term of imprisonment for 25 years to life. There is no presumption in favor of either of the two sentencing options. In totality, the egregious aggravators outweigh the perfunctory mitigators and require a sentence of life without parole on count 1 and consecutive sentencing on the remaining counts. The court should sentence the defendant to life without parole on count 1. The nature and circumstances of the crime are irrational. Thank you. The defendant murdered her husband in the presence of their young children, using a poison for money, and after trying and failing to murder him 17 days earlier. The Utah legislature recognizes that homicidal poisoning and murdering for money are each so heinous to individually warrant the death penalty. Here, the jury found the defendant guilty of both aggravators. The defendant chose poison. Jurists throughout time have recognized the particularly heinous nature of homicidal poisoning. Of all the species of deaths, the most detestable is that of poison because it can, of all others, be the least prevented either by manhood or forethought. That's from William Blackstone Commentaries in 1769. That's going way, way back. The Florida Supreme Court has called poisoning a conscienceless, pitiless crime. The California Supreme Court observed, a murder carried out by deliberately giving a victim poison is more cruel and aggravated than other malicious and intentional killings, both because of the killing involves preparation and planning, and because the killer intentionally deprives the victim of any chance of escape or self-defense. Wow. Let's see. The prisoner acts surreptitiously, thus avoiding detection. Often, the poisoner acts surreptitiously, thus avoiding detection, often betraying the most intimate trust. Here, the defendant betrayed the most intimate trust of her husband and her children. The defendant decided that Eric Richens' money was worth more than his life. Courts have consistently recognized that spousal murders motivated by money are especially egregious. In one such case, the Arizona Supreme Court observed, the killing in this case did not arise out of the heat of passion, fear, struggle, or attempt to escape. The killing was not the just result of momentary premeditation, but the defendant's deliberate, carefully conceived, meticulously planned, and cold-blooded scheme to kill, rather than divorce, his unsuspecting wife. Now, in this case, obviously, it's the wife who was doing the scheming and the husband who died. The New Jersey Supreme Court observed, these killings do not stem from some powerful visceral emotion, but rather from greed and expedience. Furthermore, few crimes display a more callous disregard for human life than the premeditated decision to seek profit by way of homicide. It evidences an abandonment of all the rules that society has constructed to maintain communal life and warrants the fullest condemnation and retribution. The impact on the victim's family is irreparable. Fathers are not meant to bury sons, and losing a sibling is just losing a piece of yourself. But there are no greater victims in this case than Eric's 3 young boys. The defendant took both of their parents from them. The aggravated murder was a crime of domestic violence in the presence of children. Eric Richens was a good husband. He cared and provided for his wife and even protected her from herself. Eric was a good father. He knew that the defendant tried to murder him on Valentine's Day, and he also knew that it was unsafe for his children if he were to leave the home. Eric died protecting the boys, and they know it. Oh my goodness. And they know it. CR was 9 years old when his mother murdered his father. He is now 13 and wears his father's clothes to school. Following Eric's death, DCFS supported a finding of emotional and physical abuse by defendant against CR. See State Sentencing Exhibit A. He and his brothers have participated in intense therapy since the defendant was arrested 3 years ago. CR wants the court to know that my dad was a good person and very thoughtful and kind and helped whoever needed help. And that, quote, I'm afraid if she gets out, she will come after me and my brothers, my whole family. I think she would come and take us and not do good things to us, like hurt us. I miss my dad, but I do not miss how my life used to be. I don't miss Corey. I will tell you that, unquote. Holy smokes. From a 13-year-old. AR was 3 weeks shy of his 8th birthday when his mother murdered his father. The defendant made AR her alibi, thereby condemning her child to be a material witness. If called to testify at trial, AR would have recalled being put to bed early on March 3rd without bathing, which was unusual for the boys. The television was playing loudly inside his parents' room, and when AR tried to enter, he found he was locked out. AR used a broom to try to dislodge a key from above the door frame, intending to unlock the door and enter the bedroom. AR accidentally hit the wall with the broom, making a noise that attracted his mother's attention. She yelled at AR to go away. She later entered his room and asked him what he needed. AR pretended to be asleep because he was angry with her. later during the night, his younger brother, WR, woke up and tried to enter his parents' bedroom to sleep with them, as was his habit. WR also found himself locked out and slept in AR's bed instead. AR would have testified at trial the defendant did not sleep in his room with him that night she murdered his father. Oh my goodness. AR wants the court to know that my dad, quote, my dad can't be my coach anymore and can't be at any of my games. He won't be at my birthdays. He can't teach me how to drive. He won't be at my graduation, and he can't take me camping or fishing. And that, quote, I don't want the defendant out of jail because I will not feel safe if she is out. With her in jail, I will be able to continue to feel safe and live a happy and successful life without fear of her hurting me or anyone I love. WR was still in preschool when his mother murdered his father. He has now lived half his life without his father and 3 years without his mother. His memories of both are limited. He remembers being scared the night of his father's murder and wetting his pants while held in the bedroom before his Aunt Katie arrived. WR wants the court to know that when someone talks about Corey, it makes me feel hateful and ashamed. She took away my dad. And that if she got out, I would be so scared. I'm worried that she would take me away. Once she is gone, I will feel happy and I will feel safer and relaxed and trust people more. Unquote. If the defendant serves 25 years in prison, she could potentially be paroled at age 57. Yeah, this 9 and 13-year-olds communication is well above their age, which does seem a little suspicious. If the defendant serves 25 years in prison, she could potentially be paroled at age 57. Her sons will be 36, 35, and 30, and likely will have their own families. The boys deserve finality and should not have to revisit their father's murder at future hearings or worry about the defendant's potential parole. Given the tremendous trauma and upheaval that the defendant inflicted upon their childhood, this court should ensure that she does not harm their adulthood. Not only should the defendant serve her life in prison, but she should serve her boys' lives in prison. This is the best closure her children can hope for. Only this court can give it to them. Katie and Clint are now raising 3 boys that require extraordinary love, support, and stability. It is best for the boys, and everyone is thriving, but Katie and Clint never planned for it. Katie never planned to administer an estate and a trust or tackle vindictive litigation. Gene never planned to work the family ranch at his age without Eric. Katie and Amy both live with guilt for not doing more to protect their brother from his wife. The aggravated murder impact extends beyond Eric Richens' family. Josh Grossman bears the weight of knowing that he contributed to the defendant's motivation to murder Eric. It has gutted him. Chelsea Barney bears similar weight, knowing that the defendant murdered Eric in some measure to salvage Miss Barney's life savings. It haunts Carmen Lauber that she unwillingly provided the defendant with the fatal drugs. Cody Wright and Josh Kays question whether they could have done more to save their friend. The defendant's character is irredeemable. The defendant is transparent. Evidence of her character is well known from all stages of this proceeding, to include her prioritizing a facade of success over everything, her fraudulent borrowing, her stealing her best friend's life savings, her persistence in murdering Eric after failing on Valentine's Day, her self-publishing a children's book for money and attention, and the aim of her walk the dog letter, among a slew of other examples. The defendant cannot check her ambition or her sense of entitlement. When confronted, she lies. When she feels aggrieved, she attacks. And she certainly feels aggrieved. She always has. In the immediate aftermath of the guilty verdict, the defendant blamed a corrupt prosecution, a corrupt judge, and unfair Summit County jurors. See the state sentencing Exhibit C. 6 weeks following the guilty verdict, the defendant texted an admirer, I will expose this county, the prosecution, the judge, the Richens, the investigation, all of it. So they can lock me away for now. That's fine. It's going to come back on them. It will come to an end. Not this year or next, but I'm not going away. I won't be silent. I'm going to expose them all for what they have done to me, my kids, and my family. This injustice. They picked the wrong one. They think sentencing is the end. Closure is just the beginning. And the end closure, it's just the beginning. They haven't seen anything yet. With a winky smiley face emoji. Most telling of her character, the defendant attacked Eric. Within hours of her arrest, she for the first time blamed Eric for his own death. See State Sentencing Exhibit E and E through T. From jail, the defendant and her family engaged in open season on Eric the Dead, releasing what they believed to be damaging information about Eric to the media. State's memorandum opposing motion to suppress letter during trial. During trial, the defendant falsely accused Eric of having an affair with a coworker and a homosexual affair with one of his best friends. The Richens children are familiar with the inescapable media coverage of this case. Many of the defendant attacks against the Richens family permeate the record. For example, she throat punched Amy Richens 2 days after murdering Eric, when Amy informed her of the Eric Richens Living Trust. Eric created the trust to protect her and their children. 4 days later, she hired counsel to breach the trust. She told Jean Richens that Eric died of the same lung mold that killed Jean's wife. Cruel. In the Walk the Dog letter, the defendant instructed her mother to release photographs of Katie's young children to the media and wrote, "Bring me home and then we'll get those dang witches." That part's blurry. It's like it didn't copy well. Referring to Eric's sisters. When confronted with the letter, the defendant insisted, in the face of all reason, that it was part of a freaking book and half true, half fiction novel about her incarceration. Other of the defendant's attacks against the Richens family are new to the record. For example, when the estate's investigator found blank statements with Corey Richens Realty's account header and CE's account details, the defendant accused Katie and hired counsel to advocate for the criminal prosecution of Katie. While detained pre-trial, she caused her family members to pursue federal firearms charges against Jean for removing Eric's firearms from the Willow Court home for safekeeping, file false reports with DCFS against Katie, and report Amy Richens to the police for marijuana possession. To this day, the defendant maintains insurance policies on the lives of her children. The Richens family will not be safe if the defendant is ever paroled. The defendant attacks extend beyond the Richens. While detained pre-trial, the defendant caused her family members to file unfounded bar complaints against the Summit County attorney and chief prosecutor and post a gay dating profile of the lead detective online. The defendant also made an unfounded criminal complaint to the FBI about Eric Richens' business partner. Wow, this is a lot. The defense character is evident despite her well-crafted facade. Eric surviving Valentine's Day, 3 years of pretrial detention, and a resounding guilty verdict has only amplified the worst of her character. It did not remedy it. She has expressed no remorse and has indeed publicized the opposite. The irrational nature and circumstance of the aggravated murder, its irreparable impact on the Eric Richens family and others, and the defendant's irredeemable character prove overpowering aggravation. Any mitigation the defendant presents will only be more facade. It is all she has, but even if credited, it cannot outweigh the aggravation. Accordingly, the defendant has earned the maximum punishment, short of death, and public safety requires her permanent incapacitation. She has well established that rehabilitation is beneath her. Life without parole, combined with the intense publicity cultivated by the defendant and her counsel, will also deter would-be prisoners from coldly murdering their spouse and their child's parent. The court should sentence consecutively on counts 2 through 5. The gravity of the attempted aggravated murder is that the defendant learned from her mistakes. She learned to obtain something stronger and to administer it in a way that prevented Eric from realizing the poison's effects until it was too late. The circumstances of the attempted aggravated murder are identical to the circumstances of the murder. The gravity and circumstances of the frauds and forgery punch above the charge's weight because they encompass the defendant's motive for murdering Eric and the pecuniary gain aggravator. The defendant's character, as discussed in IC, subsection IC, is irredeemable. Accordingly, the defendant earned distinct punishment for counts 2 through 5, and the court should sentence them consecutive to any other sentence. I don't think they will. I believe that some of those counts will be served concurrently because, like the signing, the forging, the presenting false documents, and things like that. I think some of this will be wrapped in and say this is all some of the same act. They'll be separate to the murder charge or the aggravated murder, but I think they'll merge with each other. or serve concurrently. The court should enter a continuous protective order in favor of Eric Richens' family members. The defendant was convicted of domestic violence, aggravated murder, and attempted aggravated murder. Utah's Criminal Protective Order statute provides that when a perpetrator is convicted of domestic violence resulting in a sentence of imprisonment that is to be served after conviction, the court shall issue a continuous protective order at the time of sentencing, limiting the contact between the perpetrator and the victim unless the court determines by clear and convincing evidence that the victim does not have a reasonable fear of future harm or abuse. The protection may include any order the court considers necessary to fully protect the victim and members of the victim's family, and added in bold and italics. Utah, that's Utah code. Here, Eric Richens is the only victim under Utah's crime victim statute. Paradoxically, Eric Richens' family members, including his children, are not victims. It is evident that Eric Richens does not have a reasonable fear of future harm or abuse, which is the Criminal Protective Order statute's threshold inquiry. Thus, the Criminal Protective Order statute yields the absurd result that family members of a domestic violence murder victim are left unprotected when the family members of all other domestic violence crimes can be protected. Wow. Sounds like Utah legislature has some fixing of the law to do. The kids are not considered victims. This is where the absurdity doctrine comes into play. Courts will apply the absurdity doctrine when the operation of the plain language is so overwhelmingly absurd that no rational legislator could have intended the statute to operate in such a manner. This standard is satisfied only if the legislature could not reasonably have intended the result. That's Bagley versus Bagley from 2016. The standard is satisfied here. Clearly, the legislature could not have reasonably intended to accept the family members of domestic violence murder victims from protection. The defendant's conduct and the victim impact statements firmly establish that it is necessary for the court to protect CR, AR, and WR from their mother, as well as Eric's father and his sisters and their families. Anyone can appreciate the family's fear resulting from the defendant maintaining insurance on the boys' lives. See the exhibits F, G, and H. Accordingly, the court should issue a continuous protective order under the Utah Code that prohibits the defendant from contacting Eric Richens' family members unless they first initiate contact, and prohibits her from maintaining or benefiting from insurance on the lives of the 3 children. The court should order the defendant to pay restitution. We're almost at the end here, guys. Restitution comes at the end, and then a bunch of attachments. Utah Crime Victims Restitution Act requires district courts to determine restitution for any pecuniary damages proximately caused by the defendant's criminal conduct. Insurance companies are victims under the statutory definition. Additionally, the defendant is a killer within the meaning of Utah's so-called Slayer statute, which provides that a wrongful acquisition of property or interest by one who kills another shall be treated in accordance with the principle that a killer cannot profit from the killer's wrong. You can't kill someone for the life insurance money in Utah. The Slayer doctrine prevents that one. Slayer statute. The defendant received $1,017,018.49 from Auto Owners Insurance Company and $352,562.61 from the True Stage Insurance Company as the beneficiary of insurance on Eric's life. These insurance companies paid out as a result of the defendant committing aggravated murder as convicted in count 1. Moreover, True Stage paid out because the defendant committed insurance fraud and forgery as charged in counts 3 through 5. Accordingly, the court should order the defendant to pay restitution to Auto Owners Insurance Company in the amount of $1,017,018.49, and True Stage Insurance Company in the amount of $352,562.61. This is interesting. She doesn't have any money that I know of. I mean, not much. She's on public defenders now, right? And the house isn't hers. It belongs to the trust, so she can't sell the house to satisfy any of this debt. I don't know what assets she still has to her name, significant ones that other than a potential book deal or something, but all that money under the Slayer statute would be taken away anyway. The court should order the defendant to pay the recoupment to Summit County. After Ray, Quinney, and Nebeker abruptly withdrew from this case in May of 2024, the court declined to require the defendant to complete an affidavit of indigency, citing Fifth Amendment concerns. The court found that the defendant was indigent on the sole basis of former counsel's representation that the defendant does not have access to financial resources sufficient to retain private counsel. Interesting. So she might have money, but she doesn't have access to it. The Summit County thus became statutorily obligated to provide defense services to the defendant. The cost of these services will exceed $1,391,943.98. That's a lot of defense money. You guys think this one through. If you're planning on murder, it's expensive to fight the charges. If the court learns that an individual provided with indigent defense services is in fact not indigent, the court shall order that individual to pay the indigent defense system the cost of services. The defendant continues to litigate claims to Eric's premarital home and a share of the trust. To the extent that any of these assets or any of the other assets are adjudicated to the defendant's property, the court must order the defense costs to be paid to Summit County as recoupment for indigent defense services. I wonder whose priority comes first. Does the court get paid first? Do the insurance companies get paid first? Who has the primary claim? There are still some stuff in litigation. Thank you, Baby Shark. I'm making sure Shells is aware of the cost. Lee, yes, please. Highlight this for us. Lee, it's not worth it. Trust me. Lee, that's funny. Additionally, the court may order the defendant to pay costs for expenses incurred by political subdivision of the state for attorney's fees of counsel assigned to represent the defendant. To the extent the defendant or her representatives or assignees receive any money that is not subject to the Profit for Notorious Criminal Activity Act, the court should order the money to be paid to Summit County as recoupment for the indigent defense services. The court should sentence the defendant to life without parole. This is the conclusion. Among the state's other sentencing requests, this sentence is appropriate considering the crimes that she committed, their impact on her children and Eric Richen's family, and her irredeemable character. This sentence serves the interests of society which underlie the criminal justice system. Most importantly, no other sentence can provide CR, AR, and WR with the comfort and protection they need and deserve. And that was dated yesterday, signed by Margaret Olson, who's the Summit County attorney. Well, it's got Margaret Olson's name on it, but it was signed by Brad Bloodworth, who was the prosecutor. So Brad's the one that filed it, and the attachments are not attached, which is great. All right. Looking at the clock here, it is 12:49. Just trying to see if we have... Judge Boyd is still... She's still doing docket work.
In his vehicle, right? No, he was outside the vehicle right now.
How far away your residence was his vehicle?
They've got a witness they're questioning.
Let me ask you.
50 yards maybe?
50 yards.
Or less than?
50 yards away.
Okay, we're gonna let that sit for a while. Hang on, what's going on here?
Ms. Kamari, do you have...
Is Kevin Burnett
Yes, Your Honor.
playing the game right now?
I'm ready with Shane Iverson
He's got a pair of
on the
binoculars.
9:30 calendar.
He's got a pair of binoculars on his desk, gaming headphones.
I'm present.
He's hunched
What's
over a
happening
computer.
today with that?
Well, I filed a motion to reconsider the
Backpack
original
on the floor.
sentence. You were the sentencing judge.
This is on for a sanction hearing?
It is on for sanction hearing, Your Honor. And so in my motion, I requested that the sanction hearing
Now
be
he's gone.
reset until the motion to reconsider had been heard. Since you're on the calendar this morning, I would request that that motion be heard this morning.
I didn't realize it was on for a motion this morning. Usually
It
those
wasn't
are set.
originally, Your Honor. It was just for the sanction hearing.
So January 5th.
All right, we're going to be going to Judge Boyd here in a little bit. We think they have a jury. Let's see, Amber, you sent something in mod chat. Let me take a peek. Yeah. Send your email address real quickly in mod chat. I gotcha. Found you. Never mind. Okay, I just emailed it to you. All right. Let's see what else we have.
Hello.
Selena, we'd definitely love you to call in. We'd love it. I don't know how it's going to go down. We expect to be able to watch all of it, but we'd love to see your response and get some information and feedback about what you observe in the court. Trial starts at 1:30, so it would be 2:30 Eastern if I'm wrong.
Yeah, this will need to be set on a Monday motion calendar.
Yes, Your Honor.
And we can do that now. We could just pick a Monday out at some point in the future. What's that? I can't hear you when you're...
I'm sorry.
I can't hear you when you whisper and mumble.
City might want to respond. City sent an email. And then did I understand that a notice of appeal has been filed in this case?
Yes, Your Honor, that's correct.
Just because I'm curious, what's the basis for the motion to appeal?
Unknown from the city's point of view.
I
Unknown.
mean, they did a stipulated order of continuance, and then that was violated. I don't think there's any dispute about that. And then there was a reading of the police report. So,
Your Honor, part of the basis is ineffective assistance of counsel.
who represented him on the SOC?
Mr. Swenson, Your Honor.
Would your office be conflicted out of that? I mean, I think he would need to get a different attorney to do that then, I would think.
He does, Your Honor. So our office doesn't do, we're not contracted to do the any appellate work. And even if we were, due to the conflict, we wouldn't be able to do that. And so we are in a, right now, we're kind of in a lull as we figure out who's going to be serving as the appellate attorney.
I think that whoever handles the appellates out of, I mean, that's a separate issue from this.
But that is an issue that we're
we have different, I think Rawls appeals are handled by, I guess I don't know how that works out of different jurisdictions. I know in state cases, they have a panel of attorneys because public defense doesn't do them, obviously.
Yeah, the court rules changed on that over the last 5 years.
Yeah.
Because normally it was just handled out of that panel.
All right, well, that's a separate issue. But for today, are both of these, hang on just a
Yeah, they're
second.
both on appeal. They're both calendar.
Okay, so there's, we'll reset these, go about 5 weeks, give the city a chance to respond, be a combination motion hearing, sanction hearing. Yeah, we'll just do it that way. We'll put it on a Monday morning.
So, Lacey motion.
And put them on wherever Lacey motions go. Be June 18th at 11 a.m.
June 18th at 11 a.m.
Yes, sir.
Thank you, Judge Meyer.
And that'll be it for today on these.
Where's that at? Send me some information on that one. I like working with Utah courts, so.
Thank you.
You've been getting text reminders of court dates there, Mr. Iverson?
Yes, I have. It is a good texting number, but it's not a good phone calling number. The text is perfect. It's working just fine.
Text
That's
me,
the other
don't
thing,
call
I
me.
guess. I'm just kind of thinking out loud here. If he's appealing the case based on ineffective assistance of counsel, yet he's asking the same law firm to readdress the sentence, I think that might be a conflict in itself. So I think we're going to have to unravel that a little bit. So Ms. Kamari, that can be a conversation between you, Mr. Iverson, and the city maybe.
Okay.
And maybe somebody else. But that appears to me to be the very definition of a conflict.
Miss Mary, it should start in about
we'll go from there. But that's it for today.
hour and a half.
I'll leave you folks to sort that out for now, unless
Eastern.
it comes back before the court and it's not sorted out.
Are we still thinking it's the same case?
That's it for today, Mr. Iverson. You're free
The
to go.
Tesla? Oh,
Okay, thank you.
Kevin's back. Kevin, what you doing?
Ms. Kamari?
Yes, Your Honor.
Kevin reminds me of somebody who
I'm
plays in
ready
a Beach
with
Boys cover band.
Leona Cornegate on the 9:30 calendar.
He's in his garage, sitting next to a car, backpack
She
on the
is
floor,
present
binoculars on the
Zoom.
table.
It's on for confirmation.
Yes, Your Honor. She's resolving today with a stipulated order of continuance.
He's
And
sitting
your
on the
name is
floor.
it Leona Cornegay?
Yes,
Am I saying
sir.
that correctly?
Yes,
Currently, you're
sir.
charged with simple assault, domestic violence related. I'm looking at what's known as a stipulated order of continuance, in that the case, you and the city have agreed to continue this case without a finding for a period of a year. On the conditions, you don't have any criminal law violations, don't possess a firearm, and don't be in the same room with Mary Jolvazan.
Don't be in the same
Do
room.
you understand those conditions?
Yes, sir.
Do you understand if you comply with those conditions at the end of a year, this will be dismissed?
Yes, sir.
You understand if you fail in any of those conditions, though, you'll be brought back before the court. Your guilt or innocence will be determined by a reading of the police report. So what's happening is you're giving up your right to a trial, but you're getting the opportunity to have this case dismissed so long as you comply with those conditions. Did you review this with your attorney there, Ms. Kamari? Ms. Cornegay, did you review this document with Ms. Kamari?
Oh, yes, sir. Sorry.
That's
Yes,
all
sir.
right. Any questions about any of it?
No, sir.
Anything further from the city?
Nothing.
Ms. Kamari,
Nothing further, Your Honor.
anything you'd like to say at this time, ma'am?
What kind of car is
No,
that?
sir.
Sleuths. Sleuths do your work based on the
So do these folks
stock
live in the same establishment, or is this a
stock wheels?
That's a place one adult family home issue. So just
got it? You gonna have any problems staying away from Ms. Jolzavan?
No problem, sir.
Okay, this will be continued for 12 months. Don't have any criminal law violation without a finding. Don't have any criminal law violations. Don't possess a firearm or other deadly weapon, and don't have any contact or be in the same room with me find that name again. Mary Joel Bazan. Good luck, ma'am.
Thank you.
And you can get a copy of this off the district court website. And Ms.
Okay.
Kamari?
He's got a pair of gaming headphones in his lap.
Your Honor, I'm ready with Nicholas Vatero on the 9:30 calendar. I just sent you.
Could you repeat that name for me, please?
Soltero.
I see you.
I think they might just
The
be.
protected party is present on Zoom.
Is that Kevin? Kevin, the protected party? No, there's the bird.
On for confirmation, there's also a no contact order motion. Give me just a moment. Who's that? You're his attorney, Ms. Kamari?
I am, yes, Your Honor.
What's happening with the trial confirmation first?
I filed a motion to continue with a speedy trial waiver with the new commencement date of today.
Kevin's going to show us the car. Maybe. A little bit.
And then Ms. Sortero, I just reviewed your motion here. Anything you wish to add to that?
Yes, Your Honor. I just really plead to the court that they resend it and lift the restraining order. It's been approximately 2 months and a week that I haven't had the support overall, if it's financial and logistical, from my partner, my husband. And I just ask that it please get lifted. This has just been a nightmare of a situation.
Give me just a minute.
Victim here asking for the restraining order to be lifted. It's between her and her husband.
Let me hear from the city, and then I'll hear from Ms. Kamari, and we'll see where we're at. Mr. Sabota.
Kevin's just chilling.
I guess our position is that we would agree to a rescission if in the interim he's making positive steps to get enrolled in mental health treatment.
And Ms. Kamari, where are we at with that?
Your Honor, he is in mental health treatment. I sent the appointment slips to the clerk to show the appointments that he's completed so far. And so he first started treatment in March.
And this is at Life Stance?
Thank you, Selena. Trying to pull
yes,
up
Your
right now.
Honor.
It does appear if he's attending mental health treatment, Mr. Sabota.
Right, yeah. That's been our position with defense.
So, ma'am and Mr. Sotero, based on that, I'm going to go ahead and allow the no contact order to be rescinded. But, and I see that had an impact on you, Ms. Sortero, which I expect that. But that doesn't mean, everything's in the clear. Everybody needs to be on their best behavior out there. Do you understand that?
Of course.
Yeah, and I'm mainly talking to him. I appreciate you, but he's the one in trouble here, and he's the one who needs to toe the line. It looks like, but based on the work he's done, we'll reset the trial. I will allow the no contact order to be rescinded. But if there's any hint of any more problems, Mr. Sortero, then we'll be right back here. That'll come back. Do you understand that? So this has created quite a lot of headaches for probably everybody in the family. So let's make sure this doesn't happen again.
Yes, sir.
Or anything close to it. What do you think of your treatment appointments? Are you getting anything out of it? Are they helpful?
Yes, Your Honor. It's conflict resolution and stress related.
And Ms. Kamiri, what's the expiration date of the waiver?
Oh, I believe it's August 10th, Your Honor. Let me open
We'll
it
set
back
trial
up.
then on
Confirm.
August 5th and 6th. We'll do confirmation on July 21st. And then Mr. Soltero, have you been getting text reminders of court dates?
Yes, sir.
And then that's it. So when the rescission orders are ready, Mr. Sabota,
Yeah.
let me know.
About 2 minutes.
And
I'll let you know.
Your Honor, I
So-
got July 21st for confirmation. What were the dates for trial?
August 5th and 6th.
Thank you.
And ma'am, you can get the rescission order. It's not quite ready yet, but you'll get the rescission order off the district court website.
Okay. Okay, thank you. Sir, if you don't mind me asking, in regards to, I'm not sure if I can speak on it or not. In regards to his trial dates, is there any? I would like to either provide just a statement and or supporting documents.
Okay,
to
so hang on
kind
just
of-
a minute. Okay, I'm going to stop you there for a second. First of all, with regard to trial, if there's any, if this case goes to trial, then you'll probably have to be a witness at the trial. But what I would encourage you to do is speak with the victim's advocate at the city of Lacey, and then let your thoughts known to her. And then she can communicate with the prosecutor, who will communicate with Mr. Soltero's attorney, and things of that sort. So yes, you can certainly be heard. That's how I would suggest you conduct yourself.
Okay, I mean, I've made multiple attempts. The victim advocate has not been helpful whatsoever. I spoke to
Okay,
a
so
supervisor.
well, just again, we're not gonna get into that.
Okay.
I'm just gonna say,
Okay.
and that's what you need to do. And they're very busy and got a lot of things going on, but yeah, that's what you need to do is communicate with the city and or them,
Okay.
and let your thoughts be known.
Okay, will do. Thank you. Thank you for resending and
you're
lifting the
welcome.
order. I appreciate it.
You're welcome. And both
Spousal
of you are free to
privilege.
go.
She may not be.
Have a good day.
She may not have to.
Thank you.
Kevin, listen again. This might be
Ms.
your case.
Kamari?
Your Honor, that's all I have for individuals present.
Okay. Ms. Grisco?
Your Honor, first I'd like to address Mr. Marcos Espinoza. He is on the 10:30. His work was supposed to start at 10. He's on Zoom. Here for a preliminary FTC.
Looking for anger management.
Your Honor, I did send the anger management evaluation this
That is
morning
one
to
well-defined line.
Ms. Lopez CC'd Mr. Svoboda as well. From my read, it said that he just needed to do an 8-hour class. He has that scheduled for May 30th at around 8:45 a.m. You'd ask for him to be found in compliance at this point.
We can reset it for a date after that, just to make sure he follows through.
Yes, Your Honor.
What day did you say that was?
His class is May 30th.
May 30th. Mr. Sabota, any objections?
My thought would be to put him on tracking at this point.
Okay.
Just
give him
so
30 days to get it in, and then if he gets
Yeah,
okay.
I don't think
We
need
won't set
another
a we
hearing.
won't set a court date, and so you have 30 days from today's date to get that sent in. Do you understand that, Mr. Espinoza? If
Yes.
we don't get it, then you're gonna get it. You'll get summons back here.
Okay.
You're free to go.
Thank you.
See the difference?
The Soltero no contact order at 9 is
Got
in
it.
your
I see it
9:30
right now.
file.
Thank you. Ms. Grisco.
Thank you, Your Honor. The next matter I have
Kevin.
is Kevin Burnett.
Here
He
we
is on Zoom
Kevin.
at 10 o'clock for preliminary FTC. He did give me proof of 14 hours of his community service. He needs 2 more that he said he has scheduled for this week.
Is that the only issue?
That is the only issue that I see, Your
We
Honor.
can do the same thing, Mr. Sabota, just give him 30 days to get
Extend it
all
out.
16 hours in,
Well,
unless there's more to it.
can we see, he has an arraignment. He has an arraignment on another Lacey case on Thursday, May 21st.
Okay.
And maybe
can just
set it
back
to
this
that
up
day.
to
We
that.
have basically a joint offer to defense on the case, so.
All right. So, Mr. Burnett, get those 2 hours done. Do you remember you had a court date for May 21st on a different case?
Yes, sir.
We'll see about this. We'll just back that up. It's May 21st. That's 9 days. Can you get 2 hours in the next two?
Absolutely.
Yeah. All right. We'll see you back here on May 21st. So we'll just back
Okay.
this up to that.
Okay, great. Thank you, Your Honor.
Is that another DW? It is another DWLS.
Yeah, D3.
Okay. Yeah.
Oh, man.
All right. You're free to go, Mr. Burnett.
Thank you.
You're welcome.
DWI, he calls in from the side of his car. Kevin picks up another charge. All right. We're gonna bail on that. It's time for lunch. It's almost 1:15 right now. We expect Judge Boyd to have trial. This will probably be the last Judge Boyd trial before she's gone. I think she might have a couple. There's another one later in the year. Remember the case Judge Boyle got delayed last week? It's going to be October 27th. So that might be right towards the end of her service. I'm hungry. Yes, I'm hungry. I need to check in with my wife and see how the shipping of the doors and windows is going. So, all right. Was there anything else? Did I tell you all the stories? Was there a story I owed you? I said, remind me about something. Did I? Got this nagging feeling like I teased a story and didn't deliver. But maybe I did tell it and I just forgot. Either way, I can't remember now. And if you guys don't remember either, just make one up if you have to. Thank you, Josh. We'll be back after lunch with the docket. We'll be back in 1 hour. When are we coming back? 1 hour. Let me make a portal. Give me just a second here. I think we still have this manslaughter trial coming up. I think that's the one. We'll reuse that image that Red Pen made for us, and I spelled wrong, and I still haven't corrected. Sorry, Red. Well, no. I've got time. Let me fix this. Canva. What is fixed? Jury trial. Oh, it was. Josh, thank you. I didn't tell that story. As part of our ongoing efforts to beautify and improve our home, Mrs. R.A. informed me that it was my turn to contribute something, and I decided to clean up in my office a little bit. And so I found, buried amongst the cables, I found an old computer monitor. Works just fine. It's just 1080p, not 4K, so I can't use it for my new system. An old computer monitor we didn't need. And I found some old encoders, like the old KiloView encoders, microphone preamps, a cable modem. It's a nice one. It's like a Nighthawk cable modem, still in the box. Various and sundry, just electronics that I just don't need anymore. And we do here in North Carolina. This is one thing I love about North Carolina that we did not have when I lived out west. You don't have to throw things away. You can just put things out by the road, and someone will come and grab it. And these are items that they have some value and some life left in them, but they don't have value for me. I can't use them with the system I have. Like I've got like a BNC to HDMI cable converter. I don't have any BNC. That would work for like a security camera to a TV. I don't need that. So I've got all this stuff. And we're like, well, just put it outside by the road. And then I'm getting carried away. I'm like, oh, there's so much stuff I can add out there. We've got. So I'm digging through my cabinet. I found a metal detector I did not even know I owned. Still new in the box. It's junk. It was sent to me by a company that wanted me to tell everyone how wonderful it was, and it was not wonderful. So I've got that. I've got a, and then I found another metal detector that I don't like, and then I put it out there. Both of them fully functioning, just not good. So we have all this stuff just piled outside the road. I want to go check and see if it's still there, because we put it out late last night in the dark, and nobody took it last night. It was still there this morning. So when I go to lunch, whoa, Red, I was about to download this. Red just added a pair of pink panties to the, kid you not, look at pink panties added to the thumbnail. That's funny. Hang on, let's do this. Let's do a background remover. There we go. It's thinking. We're both working on the same item at the same time. Anyway, I need to go check and see if they're out on the, if they're gone yet. I wanted to see who got them, if they picked up everything, because there was some other stuff as well, but anyway, that's all. That's all. Yes, so now we're getting pink panties on this. Compress, download. Okay, we will do a portal. Just hold on, please. Just 1 second. Change. Download to that one. Visibility starts at 2:15. The new window is up. Anyway, so now my office is cleaner than it's ever been, and I tried to set up my rack systems for video and audio on top of each other, but it just blocks the TV and I can't see anything, so I'll have to figure out how to do that. Okay, building the portal. Let me start the music. There we go. All right, when we come back, we're hoping to have opening statements in this trial down in Texas. Which would be good, because we haven't had a court case in a little bit. Big one. Portal is created. We're all good to go. Now we're ready. Refresh, I cropped it. I got it. I think. I removed the background. I think we're all good. Tonight, when you go home, please hug the people you love, smile at someone, make their day just a little bit better. Please stay safe till we go live again in 1 hour, just under that, 57 minutes, with a little a Tesla trial. But we can't put Tesla trial in the title because I'm pretty sure Elon Musk would sue us. This is a trial involving manslaughter charge related to a car accident by a drunk driver driving a Tesla onto the sidewalk, hit a pedestrian, killed the pedestrian, left the scene, and failed to render aid. So that's where we're going. And if you want to stick around for that, it's going to be great. We'll see you guys later. I'm going to go check and see if my junk is gone. And if not, we can always add more stuff to it until it just becomes too enticing. Somebody's going to have to pick it up. I added all my Christmas lights to the pile as well. Every Christmas light I own, I threw on there. We're going to do new Christmas lights if we do any at all. So, all right, you guys have a great lunch. We'll see you afterwards. Bye-bye.